may I be permitted to mention
Yes.
item number 104, my lord. Your lordship was pleased to direct my advocate on record to serve notice upon the other side, my lord. Notice has been given to the other side, my
Item
lord.
number
104 of today's list, my lord.
104. Yes.
My lord, we have served notice upon the other side, my lord. Now, no time has been mentioned, my lord. We can intimate if your lordship give any time.
It is fixed today.
Yes, yes, sir.
Who is for the state?
My lord, Mrs. Sonal Sina.
Is this matter ready?
No,
Whether they have filed AO?
no affidavit has been filed by them.
Then
Well, thereafter, after the statutory period is over, my lord, we have mentioned the matter, and now the matter has come.
so what you want?
My lord, we want if they chooses not to file any affidavit, my lord, then without affidavit, your lordship may,
Liberty has already been given, so how can I know?
or your lordship may fix any particular date and time, my lord. We again serve notice upon them.
No, you have already served upon that.
Yes, yes.
So
we have
what is the necessary? Not required to serve again. I can fix a date.
lordship. Any day, my lord, at 2 p.m., my lord.
The 2 p.m. I usually fix the parted matters,
Lordship.
not the regular matters. Very well, I am fixing the matter under to be mentioned. Okay. Item number 104. On mentioning, let the matter be appear in the list under the heading of to be mentioned on 5th of March.
5th of March. Lordship.
In item number 104. Yes, next.
My lord, may I permitted to mention one matter. A matter is pending since the year 2015, yet not been listed. The matter.
What matter?
ACT number 47 of 2000.
Second appeal.
Yes.
Second appeal pending for
since the year 2015.
2015
15.
is not the very old.
No.
I have 74.
Prior to 1 year back, the paper book has been received by us.
And
but
most of the second appeals are of 80s and 90s.
My lord,
They are only listed.
the appellant is a senior citizen.
All are senior citizens. Some of them has expired. 64 appeal.
The notice
Two generation has expired. Now appeal is going on before me.
Prior to mentioning, notice has been served upon the respondent also.
I usually take the mentioning up to 2010, not after that. Let me dispose of some of the matters so that I can. This is why I don't allow the mentioning since 2010.
My lord, the appellant is not in possession the disputed properties. So,
what is the matter about you are the appellant?
Yes, I'm for the appellant.
And status?
Status.
Paper book ready?
The paper book is ready. And prior to 1 year back, we have received the paper book.
You have received you have prepared the paper book?
Yes. No, department will prepare the paper book and serve us.
I can list the matter only. It is not possible. It is accordingly list to become later. The old matter will become first. I can list that, but don't urge to hurt the matter.
At least it may be listed, my lord.
What purpose would be served? Okay. Take the list.
My lord, may be permitted to mention on second appeal of year 2009, my lord.
Lordship, may I be permitted to mention a matter for inclusion in the list?
What?
WPA, Lordship.
WPA.
Lordship, we have to mention one urgent application. I final petition challenging the appointment of the private restorer on the ground, on the date of here can recollect on. I mean, my ground was on the date of inquiry, as also on the date of issue of the license, private restorer, not even the godown. You will also kind enough to direct the SCFS to consider my defendant. What happened in the meantime? My client went to the office of the SCFA to submit the order, your lordship. SCFA, that time SCFA is not there in the office. That's the usual course, not there. His staff was said, until sir was said, we cannot receive the order. All right. When my client came back from the SCFA's office, the husband of the respondent number 6, he is the member of the local panchayat. Another person assault my client. Also threaten him, withdraw his complaint, otherwise their consequence. My client made a complaint before the local police did not take any step. Then my client made an application before the superintendent. Then also yesterday, he SFS having knowledge of your lawsuit order, then state advocate communicated.
Yes.
In spite of issuing any hearing notice, yesterday he tagging the ration card with the dealers. In the passing your lawsuit order, there is no tagging admitted fact. It was submitted on behalf of the state. So I file an application, my lord, and take this application, my lord. And
Application for what?
application for I only last day also I'm seeking my lordship. Lordship, don't send my client to SCFS. I know my client cannot go SCFS.
Whatever may be, you are filing an application in a disposed of.
Yes, ma'am. I cannot file any review application because all annexure my application subsequent. I cannot file any review application.
Now,
review-
how this court can entertain the application in a disposed of writ?
Then I have to file a review, man.
You may file a review application, you may file anything, but disposed of writ,
I cannot
can
file
I-
review because my lord, all facts subsequent. I cannot say before your lordship that fact I have no knowledge.
then it is a new cause of action. You have to prefer a writ. Otherwise, you have to take other steps, not before this court. You understand?
I understand, but my
But situation is otherwise, I understand.
I understand. Then I can file.
No,
a
you
writ
can
also.
file a review for reviewing the direction, not to send the SCFS to say secretary or otherwise. You can file it. You can file it. I can pass the order if you are satisfied.
I can satisfy your lordship.
Yes,
The
if you
last
satisfy
also I'm
me-
seeking because my client did not allow by the SCFS because SCFS is the
Very well. So that part can be reviewed, whether it can be sent to the SCFS or the district controller or to the secretary. Okay.
I shall file.
May I be permitted to mention one matter, Lordship? In earlier occasion, the matter was taken up yesterday, Lordship, being item number 14. My junior was there, Lordship, paid for not today because I was not there, Lordship. And subsequently, Lordship, I heard the matter. There one can application filed by the added respondent number 6. And Lordship, please to pass the direction, Lordship. Now, my grievances is that, Lordship, the respondent number 6 is here.
I have not been served any notice that.
No. I am mentioning, I will serve you notice. Now, what is my contention in this matter, Lordship, that they have come up with some documents by saying that the license has already been issued, where my application is restricted to the point that whether during pendency of the writ application, no license should be issued in favor of anyone who have applied under the vacancy notification. Now, what happened, Lordship, that there are certain discrepancies that I have to brought the notice before your Lordship in this matter. So, may your Lordship be pleased to fix the matter under the heading of to be mentioned by Monday or any other day, Lordship, as your convenience.
You serve before
They
mention.
have-
My Lord,
they
he
have-
is present
Guys,
over
they
here,
have got
Lordship.
the chance to file affidavit in opposition. They have missed the chance. Now they are mentioning when your
Very well.
lordship.
You serve upon mentioning.
Lordship, he is present, Lordship. His consent is there, Lordship.
You
Maybe
mention it,
he
you
just
mention upon service.
upon service, Lordship, I will mention. Grateful, your
Yes.
Lordship.
You mention upon service on Monday.
Grateful to your lordship.
Call the list.
My lord, in this matter, I am appearing for the appellant, my lord.
But upon my prayer, my lord, the matter was simply adjourned and fixed your lordship's fellow today. Lordship present.
Yes. What is the matter?
My lord, the fact is that
I
in
know the fact.
my
This is
lord,
can 7 of 2025.
my lord,
You prayed for a stay of the execution proceeding.
my lord,
this is your application. You have said that on 25/2 is the date for
Delivery
taking
of police.
possession by the
Bailiff
superintendent of
as well
police.
as in with the help of the police.
Very well. So you are appearing on behalf of the.
My lord, here, I just,
You are appearing on behalf of whom?
my lord, initially, my lord, the OP number 1 was expired.
Opinion
Thereafter-
number
Means
one.
respondent number 1.
Instead of, because, my lord, thereafter, by virtue of an application for addition of party, my learned friend got the legal here as a party in the proceeding. I don't know, my lord, whether inserted their serial number 1, A, B, C, D, or my lord, Roman in nomenclature. I'm
Give me the memo.
Thereafter,
Yes.
my lord, the one of the added party, whom initially we are representing, was expired. So question comes, so for the date man who has been expired as the party in the proceeding, that should be substituted by a learned friend. I can provide the legal here so that he may come up with an application for substitution. One aspect. So for the second aspect is concerned, my lord, I am asking this question to myself.
Yes.
That the initially the appeal has been filed against the order of the reversal by the passed by the additional district judge before the court below in respect of a title appeal case number 14 of 2002, and the appeal has been presented before the High Court in 2007. Appeal was admitted in 2013. Well, up to that stage there is no. Now, very peculiar, one review application has been filed by learned friend. Review 153 of 2014. My lord,
Review application filed before whom?
before the High Court. That
Re-
copy was, my lord, your lordship can, because that copy was not been.
Review against.
I
Order.
don't know. Review 153. If your lordship take trouble to the, just I'm drawing your lordship attentions the order sheet. If your lordship take trouble to the 10th February 2022.
Review.
10th February 2022. A review application being number 153 of 2016 has been presented and filed with interlocutory application Can 1 2016.
Can 1 of 2016.
Your lordship got it?
You are reading order dated
10th February 2022.
10th February 2022.
Lordship. The application is released from my list for lack of determination, since by the present application, the petitioner is seeking review of the order passed by the Honorable Division Bench.
Yes.
Now, what is the copy of the review has been served or not? I am not aware. First point. Second point, my lord, what is the review? My lord, whether any interlocutory order has been passed where my learned friend asking for review on the face of the error on the face of the record of the order, or the original appeal which has been filed by learned friend has been already finally disposed of, against that he has been preferred a review application. It is not clear to me. Now, in the meantime, during the pendency of these applications, my learned friend filed an application Can 7 of 2025, whereby he has been drawing your lordship attention that this court below has been proceeded with the execution proceeding, so certain protection to be given to my learned friend.
Yes.
Now, my lord, I am asking this question to myself. For the abundant precautions, whether the second appeal has been pending, your lordship can, because the catena of the order sheet, your lordship, because the pre-2000 and the subsequent, my lord, order sheet in the, my lord, system is very difficult to find out. Number one. Number two, whether the review application was presented by learned friend, what is the, my lord, reason for review application? Whether review application has been disposed of or not, that has not been clear to us. Third point.
No, what is the purpose of your argument regarding review?
Current.
I am not want to hear
Correct.
the review application. Review
Lordship.
application was filed against the order of division bench.
Lordship.
So single bench has released the matter. Let it be heard by the division bench if they want to press.
Correct. Again, this application has been present before the single bench. Again, this matter was brought before the single bench. Can you appreciate? I try to assist before Lordship so that your Lordship can take up this issue.
No, whether review is listed.
No.
Review is not
No,
listed.
that has not been mentioned before Lordship. But difficult on my part. Because
My
Your
lord,
after-
difficulty you may have.
can you appreciate?
But can say what your submission regarding can 7, that why which is listed today before me. Review was not listed before me. Whatever they done with the review, they are concerned. And you may raise objection about the review, that is the other way. But can 7 is pending before me. What is your submission regarding can 7?
Or just for abundant prevision. Can it 7
ক্যান 7 এ তোমাদের কপি দেওয়া হয়েছে?
একটু
তোমাদের ইয়েকে দেওয়া হয়েছে দেখো না।
এটা can 7. My lord, if your Lordship kindly come to the page 2. Can 7.
Yes.
My lord, the Horan Noskor was expired.
Horan Noskor was expired.
When?
My lord,
My question is when?
Just. I tried to give the my lord death certificate. He was expired on 20th April 2020.
My lord, whether
2020.
whether any communication has been made with regard to that, as per order 22 rule 10, he should have to make a communication that that person has expired. Then only we
Is there
can.
liability upon the plaintiff to
It-
make a substitution
The- the- the-
application?
My lord, it is
However-
their liability. It is
However-
their liability.
No, always not their liability.
My lord, it is their
Why?
person.
Why you are not?
My lord, we are not aware about the fact. Only on 2025, they have filed an application before the learned court below that person has expired on 2020,
When they have informed you?
2025.
2025, they will take steps.
My lord, that's why I have prepared an application for substitution. I would
Okay,
file the same.
Take steps.
That no steps has been taken by them with regard to as per order 22 rule 10. They should have to inform me about the fact.
My lord,
That necessitates an application to be sir.
Yes.
That
my lord, so for the application 7 is concerned, my lord, my learned friend, আপনি কি আমাকে কপি এটা প্রোভাইড করতে পারবেন অন মাই কস্ট?
না আপনাকে দেওয়া হয়েছে এবং আপনি যদি চান আপনি
না,
এক্ষুনি দিয়ে দেন।
কোথায় পাঠিয়েছেন?
আপনাদের লোয়ার কোর্ট অ্যাডভোকেট
affidavit
কে?
of service, cost is not required. We will give you
না
a
No,
copy.
so that I can assist you
No, of
at the
course,
time of
you can take my copy also. I can have a Xerox. It doesn't matter.
লিখে যান ওটা দেখে আমি তো
তার কোনো অসুবিধা নেই। শুধু আমি চাইছি interim stay থাকুক, let it be heard. আর কিছু বলছি না।
কোর্ট এটাকে আজকেই ফিক্স করুন
না, আজকে কি করে করবে? Let him have a copy.
সেকেন্ড অ্যাপিলটা ফিক্স করুন এর জন্য।
ও সেকেন্ড অ্যাপিল তো সবার হয়ে অ্যাপিয়ার করছেন না।
না
Possibly, I have been told that my learned friend is not appearing for all the degree holder. Unless he appears and take wakalatnama for all, the appeal cannot be heard out.
No, admittedly, one respondent has expired. You
Yes,
have not taken any
they have-
step.
No, my lord, so far as one who expired, they have already been impleaded. He appears for one of the legal heirs. The other legal heirs, he needs to file a wakalatnama if in case they gives or in their absence, it may be taken up. But all that we now pray that in view of the fact that despite bringing the fact before the court below, my learned friend's client along with others are proceeding with execution, an interim stay of execution proceeding, let this application appear after 15 days. If he intends to appear for all, let it be heard and disposed. And the appeal also, obviously, we have filed paper book. It is also before your lordship. This also can be thrust out because once an substantial question of law is formulated in appeal, it has to be disposed on the question of law formulated. Since my learned friend is not appearing for all, these are,
My lord, one modest prayer.
so he cannot take advantage that on the one hand he is not appearing, on the one hand he will go on taking head. Therefore, all that we want that your lordship will grant me not the interim order in this application granting
The
stay of execution.
Interim order,
Let it appear after any days.
interim order already there. Already protected my learned friend's clients.
তাহলে ইয়ে
Because,
executing court কি করে
because
বলছে?
if your lordship take trouble to the order dated
Nichu court order
17/6/2014. Your lordship kindly peruse the order sheet.
I have already perused the order. You just
So,
Justice
abide by the pending appeal which has been granted by the
reason of the second appeal will be
lordship. So, my learned friend Agoni, with regard to the execution proceeding was continued since 2010. We are standing on 2005. If the lower court should not respect with regard to the high court's pendency of the matter, they can dispose of much earlier. But I am not on that. I just try to find out, because subsequent we come into the pictures and I am not aware of the entire development, because this application has been filed in only 2025, recently. My learned friends submitted before lordship that they have submitted before the lower court. My lord, I being the officer of the court, at least I am requesting my learned friend kindly a copy to be given to us so that I can at least assist your lordship for deciding this application whether interim order is further required to be given or not in respect after 7 days, 10 days, any date. I didn't know mine.
Copy we have already
If your
said, I
lordship
am giving
thinks
him.
there is a prima facie interim order is required to be,
Because
because this
court
matter
order
was pending since
নিচু কোর্টের order এই
2006. Appeal was admitted 2014
execution.
without taking any proper
এইটা?
steps. Thereafter, paper books.
কোনটা বলছেন লাস্ট
I don't know.
অর্ডারটাই তো আছে
Obviously,
227
they have been
পেজ
formed paper book, their own cost on.
227 পেজ
So
227
your lordship kindly direct my learned friend to take steps accordingly. The others legal is to brought the party in the proceedings. So on the returnable date when we come up, then your lordship can dispose of the applications.
The difficulty is not, my lord, in giving a copy and coming back. The difficulty is that despite bringing all these facts, in one hand, my learned friend says that let him give a copy, let it be adjourned. In the other hand, he is taking aid of this, that to have the decree executed. Therefore, your lordship directed me, you see what happens on the next day. Though we took steps, my lord, the learned advocate appearing in the court below insisted that let an order be passed. And the learned trial judge fixed, my lord, 25th February. All that I want for
delivery of
the
poison.
time.
illegality is there. Why are you making us so hard?
I'm sorry.
They have allowed to proceed the execution proceeding, they are proceeding.
No, the difficulty is
When the order of possession is passed, then you have revised.
the order of possession has
Yes, that is the procedure of the execution case.
yes. Now, my
You
lord,
have never filed any application to stall the execution case.
no, I have filed.
No,
It
you have
was
not filed any
50,
application
no,
before.
no,
this
it
court.
was
You know,
filed. 159.
stall.
Justice Vivek Chaudhary, my lord, passed an order granting stay. 159, page
155
155. Kindly have a turn to 155.
That is the 2020.
2020, the execution application was there since 2010. My learned friend is right that in 2010 an
No, you
application-
file and substitution 25 is the date. Prior to that, I
কবে
said
আছে
dispose
কবে
of the
ডেটটা ফিক্স আছে
25
Can it be, my lord, can it
কবে
be
নিচে
possible to
কোটে
take
date আছে?
24 so that they may steps and come up before lordship?
ডেলিভারি পজিশন আছে
25th has been fixed for delivery of
Where
possession.
from the order you are reading from?
অর্ডারটা দাও ওই লিচু কোটের অর্ডারটা
নিচু কোর্টের অর্ডারটা কোথায়
কোথায় দেখো জজ সাহেবকে যে 25 এর ডেট হ্যান্ড
এই তো 25 তুই আপনি তো লিচু কোটের ডিগ্রি হোল্ডার
আপনি
তো
আপনি
আপনি-
বলেন না দেখেন জজ সাহেবকে কোথায়
Very well. No, just wait. Come on 17th with your application. I shall dispose of the substitution application. Thereafter, I will pass the order in respect of this matter. On 17th, and you collect your copy. They have served
giving
the,
him a
they have
copy.
already served the application.
I am giving him again a
If you
copy.
want to file any objection against the can 7,
in the meantime, my lord.
in the meantime, it would be fixed. The application is again fixed on 17th of February.
So kind of
Okay,
so kind
you
of
file applications of substitution, anything, I will take up the matter. Within the meantime, you file the substitution and serve the copy. So that I can dispose of the substitution
Yes.
and the
Yes,
can
yes,
7
yes,
on the same day.
absolutely correct.
Yes.
আপনার
The application was
আপনার
filed
ফোন
in
নাম্বারটা দিন
2010.
নিশ্চিত
Execution
আমরা ফোন
application.
নাম্বারটা
The appeal was admitted in 14. They
Okay,
were
this-
not taking steps, therefore it was lying
Very
all along. Grateful, your lordship. ঠিকই বলছেন, substitution না নেওয়া হলে grateful, your lordship.
Appellant is directed to take appropriate steps regarding substitution of deceased respondent, regarding substitution in respect of deceased respondent. Let the matter appear in the list on 17th February under the same heading.
In the meantime, if any objections in with regard to the office, you can add one link.
In the meantime, the respondent is at leave to file objection
If any,
against, if any, against applications.
so kind of law.
Call the list.
My lord, may be permitted to submit one thing, my lord.
What?
My lord, kindly record that I have already served the copy of this application number 7 to the opposite party.
What is affidavit of service file on behalf of the petitioner is taken on record.
And I already served my copy to the opposite party, my lord, right, on this court, my lord.
Copy of application 7 of 2025 be served herein now to the learned counsel appearing on behalf of the respondent.
Oblige, my lord.
That can appeal ডিগ্রি সাইন করার একটা অর্ডার আমি করেছিলাম, সেই একই অর্ডার, সিমিলার অর্ডার, ডিগ্রি সাইন করার অর্ডার, ঠিক আছে? Next.
Lordship, come for the petitioner, I'm praying for a short pass through. You have to,
Why pass over? What is the matter?
Lordship, we have to file an opposition, Lordship.
Yes, take the mic. Take the mic.
Lordship, we have to take, file an opposition in the matter. So,
You have filed opposition in this matter. Who are you? You are the petitioner.
yes, yes, Lordship.
What opposition you have filed? You are the criminal revision. Criminal revision, you have the petitioner. Who filed the opposition? Why you filed the opposition?
That's the
Opposition supposed to
instruction
be
I
filed
have,
by the
Lordship.
opposite parties. Yes, they have preferred opposition. Whether you wanted to file any reply.
Yes, Lordship, that's the instructions I have right now. That's why I'm asking for a short passover, Lordship.
What instruction you have?
That we have to file an opposition in this matter, Lordship.
Opposition has already been filed by the opposite parties. Who are you to file the opposition? No, reply has, you have also filed the reply. You have already filed the reply.
Lordship, please kindly grant
The
our.
matter is ready today.
Lordship, kindly grant a short passover, Lordship.
What? Why pass over? Let the matter go out of the list. Why I said pass it over?
Fine.
You are the petitioner in this matter.
Yes, Lordship.
Yes, what is your submission in this matter? Yes, you prepared opposition. Opposition, you are the petitioner.
No, my lord, I am for the petitioner, my lord.
Yes, you are the petitioner. You filed the criminal revision.
Yes, my lord.
The opposite party number one has filed one opposition,
Yes, my lord.
and you have also filed one
No,
reply.
lord. My lord, it was in the brief, my lord. But now
What?
by the reply, my lord.
Reply is filed. You filed the reply. On the last date, you have filed the reply. File with the record. Your reply is with the record. Why you are submitting like that? The matter is otherwise ready for hearing today. What is your submission in respect of the criminal division? Just argue the matter. Your reply is here. You have
My
filed
lord,
the reply.
sincerely apologize for that.
Yes.
But I'm just praying for not today, my lord. I'm not instructed to say anything. I am not prepared also, my lord, in this week. But kindly adjourn the matter for today.
Why such a matter would be urgent? This is you have preferred the criminal division against the interim order of interim maintenance,
Yes, my lord.
which was turned down, by the learned
Yes,
court,
my lord.
learned magistrate.
Yes, my lord.
So what is your grievance here?
My lord, I'm not gone through the brief, my lord. But just I'm praying for not today, my lord. Only for today, my lord.
No, that cannot be done.
My lord, then
I have
kindly,
some other
kindly give me
business
the
to do.
liberty, my lord, of 15 minutes, my lord. My senior will come. He's on his leg number, import number 237, my lord. I
Come
just
on,
came from there.
come on, March.
My
Not
lord,
this
only
one.
for just liberty of 15 minutes, my lord. I just came down from 237, my lord.
No, that cannot be done. I have some other determinations, you know.
I know, my lord. Just
Then-
liberty of 20 minutes, my lord.
No, that liberty cannot be given. You just come on next week. Okay,
Next week,
not this week.
deeply obliged.
Mr. Shishano Bandyopadhyay is appearing on behalf of Learned Advocate General, my lord, because in this matter the virus was challenged.
Appearing to the state.
Initially, order was passed. You'll also will kindly come to page 9 in my application. Till disposal, considering the pendency of the appeal pending before the division bench presided over Honorable Chief Justice. Page 9 of my application. Iris challenge করেছিলাম Iris challenge করি
virus challenge আছে আমরা appeal করতে পারি
আপনি অ্যাপিয়ার করে Iris challenge করেছিল
লাস্টের দিকে বিএড চৌধুরীর কাছে সবটাই ভাইরাস হয়ে গেছিল না জাস্ট
ও আচ্ছা
অ্যাডভোকেট জেনারেল appeared একদিন রেয়ার নেই রেয়ার নেই
আমি সেটাই বলি Iris challenge করি
স্যার নেক্সট অর্ডার হয়েছিল টু appear
Lord, this matter I am appearing for the addition of party. Just I tell you, Lordship, this matter I am appearing for the addition of party. My Lord, on the other day, my Lord, kindly just, my Lord, on the other day, I moved a writ petition, and your Lordship was pleased to pass an order on 30th January 2025. Mr. Ramesh Dhara, kindly hand over the order.
Yes, I already handed over.
Kindly see the order 30th January 2025. Then your Lordships can remember everything, my Lord.
I already handed over, sir.
এটা কোনটা এটা তোমরা ধারণা তোমরা অ্যাডিশনাল পার্টি ফাইল করেছো অ্যাডিশনাল পার্টি ফাইল করেছো
Now, in that matter, my Lord, your Lordship directed to grant the license,
Yes.
and accordingly, license has been granted. Now he is coming up with another application.
No, you have received the license.
But-
Yes, I have received the license.
This matter
In terms of your Lordship's order.
application or not for addition of party
Whether you have filed any application?
Can one minute.
Yes,
কপি দাও একটা আমাকে কপি দাও
And one is there. Yes.
I have not been served a copy of the
no, no,
application
you are getting interim order one after another without having the affected person as party.
Sir, you have filed an application you must serve a copy of the application
He knows there is the application.
ফাইল
Can
সার্ভিস
one out
করেছো
there.
সার্ভিস করেছো
No, you have filed, whether you have served the copy. Then you serve a copy.
That's like.
All right, my Lord, let him serve the copy. Your Lordships can take up in other day.
but what happened my lord that just now I have received the copy
Come on 17th?
at 17 there is some difficulty in that event by as my learned senior friend has says that they have issued the license in the meantime the respondent should not issue the allotment
No, 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 no. No, no, no. Without
They they have served the
allotment
copy
has also been made. Allotment has also been made.
I don't know my lord they have
No,
served the copy right now
Without making affected person as party, you will be moving one after another applications.
Sir, my
That's
learned
also
senior
not
friend
proper.
was appointed probably right now at the when I have filed the writ petition probably he was not appointed
No, on the 17th, what is the
but
difficulty?
in the meantime they should not 17
No, no,
is
no.
today we are on 11 only
No, then,
Well-
then the matter has to be heard. Without them.
yes
how
your
can
lordship
I-
has to be hard
No, no, they must have to be added in the.
yes they have to be added but when
They
my
have to be
what
added
my
in.
learned senior friend is saying
Otherwise-
that I have not made him party
The
probably my
17th
lord,
is
he
the
has been
Monday.
added he has been given the license after filing my writ petition at the time of filing the writ petition he has not been affected so far my understanding is concerned anyways your lordship fixed a date 7th I have no
But kindly fix it on 19th, my Lord, I will be remain there. 19th, kindly.
19th,
19th.
Wednesday.
Wednesday. I will be there, my Lord. I will personally I will remain present.
And can 2 is your application.
my can 2 is my application for appropriate order
Okay.
And my Lord, in the meantime, let them my Lord, give us a copy of the writ petition.
can we first add it
Can 1 and can 2 both are in the list.
yes ma'am
Please take down.
but
Yes,
your lordship is fixing on 19th
Yes.
And I don't know when the license has been issued in favor of my learned senior friend's client.
Yes, it's already 6th February.
6th February. Probably allotment has not yet been issued. Probably.
Tagging also is given now.
The allotment has been issued. Allotment has been made.
Tags was already.
Yes, yes.
Allotment has been made.
Interim
Allotment.
order was
No,
the
don't
tagging,
don't be
not to allotment.
so niceties of the words. Only you will enjoy the benefit, is not that.
That you have
But
to
we have
come
been
with
given
proper
license,
instruction. Otherwise,
license will follow.
your submission is nothing.
Whether the
You
license,
have to come with a proper instruction.
Once, my lord, the cards are tagged and detagged, my lord, allotment is not his concern.
I have to be concerned. It will be
But
detached from my.
Certainly not. You are
from
not
my-
State
concerned.
to give to private
From my-
respondents, my lord.
Very well, very well. Please take
But
up.
in terms of your lordship's order, everything is being done now.
Only to that effect, my lord. Let them
No,
maintain
no, no.
status quo
Milord,
till
that-
19th.
Prior to that, you
But
have
we have served the copy
before
today
passing
itself.
the
Now
interim
they
order,
are saying not to
kindly
pass the interim
no,
order.
no, Milord, no.
By the strength of my lord's order.
They
no,
have
no.
got to have served the
Milord,
copy.
I am opposing this. Milord. I am opposing, strongly opposing this. No.
Had they have so much
Milord,
interest.
this is no. Milord, I have got my interim order. Your lordships cannot invalidate.
They have
Your
not served the
lordships
copy. They have right
your
now. They have served the copy of
order
the
passed in the
application for addition of party.
How can I? Milord, your lordships cannot. Milord, today, today, if any order is passed, that will your lordships will invalidate the order which has been passed by your lordship on 30th January 2025.
I understand. I understand.
Yes, all will be hard on 19. Let us go. Come.
I have no problems.
No, no.
And-
Let it
Okay,
be hard on merit also.
Okay, Mr. Bandhavada, I heard. Can one is an application
Yes,
filed
my
by
lord.
the petitioner?
No, my can to
filed
is
by the-
mine.
Okay, can two is an application filed by the petitioner for appropriate order? Full stop. Can 1 of 2024 is an application for addition of parties?
24 applications.
Application can 1 of 2024 be served
No
herein
advance
now
copy, nothing.
upon the petitioner? Full stop. Learned counsel appearing on behalf of the learned senior counsel appearing on behalf of the added respondent submits that the license
But he has not yet been added. Proposed to be added.
proposed added
Proposed to be added.
proposed added respondent submits that the license in connection with the FPS has already been issued by the
February, my
in
lord.
favor of the in favor of the proposed added respondent on 6th
6th
February
February.
2025 in pursuance to the
Pursuant
order
to
of
my
the
lord's
court
order.
dated 30th January 2025. Full stop. On that score, he intends to add as a party in the
Original
instant
slide
proceeding.
refiled করেছে Diagonal.
The petitioner intends to use opposition against the application. Let the application be fixed for hearing on 19th of February 2025. Full stop. Learned counsel, next one. Learned counsel for the petitioner seeks an interim order in terms of
The order of the
prayer
whole division.
made in Can 2 of 2025. Considering the circumstances, it appears to me that the application being Can 2 of 2025 is also fixed on 19th. The prayer for interim order can only be considered after hearing the
Grateful, my lord.
added respondents. Proposed added respondents. 19th.
In the meantime, what happened, my lord, if they make allotment or detag my card, what will happen, my lord? And I don't know.
Merit of the writ petition.
But why? I don't know. This is a writ petition as I have need a copy of the in the original side. writ petition-
Original side order is there.
I don't know what is the order. I have not been made
Yes.
party in this writ petition.
Grateful, my lord.
But in the meantime, you also can record in the meantime, if any steps taken, that they shall be advised by the result of this application.
No. This is nothing. It is always can be done.
The merit is there.
Merit is there.
Merit is there.
In the
If
meantime,
you are
what
successful, then
Hmm.
everything will be gone.
as
If you are successful, everything would be gone.
as well.
Right. Deeply obliged.
Yes. Next.
Lord, in item number 14, the vacancy has been rejected, cancelled. My lord, no suitable candidate was found. So, my lord, the writ has become infructuous now. So this is available in portal also, my lord. The vacancy concerned at Shargachi Bazar near Shargachi Bangia Gramin Vikas Bank. It has been, rejected by the DDPS. Why, Milord? Because during the DLFP SSC inquiry, none of the candidates were found suitable. All of the candidates were awarded 0 by, the DLFP SSC. Now, kindly see the fourth last column, marks by DLFP SSC out of 25. Everybody has been awarded 0. Therefore, the vacancy has already been cancelled. So, this writ has become infructuous. Because this writ, was for challenging this vacancy.
Number 32.
Kindly take space number 32. The place of vacancy will match, Milord.
এই তো no,
the vacancy ID matches as well.
Okay.
No has been
The
matched.
writ petition was filed to withdraw or resign the vacancy.
My lord.
The vacancy has already been rejected.
And,
Because none of the candidates were found suitable, Milord. So, Milord, new vacancy will be notified as and when it can be challenged. It can be.
That is a separate cause.
That is a separate
Man,
cause.
you will also kindly give me 1 day's accommodation. Let me take instruction. 1 day's accommodation.
You take the prayer. Prayer is to.
No, whether this paper I have to take in. So one, you also can't accept tomorrow as 2 emails. I have no issue.
This paper, Milord, is from the portal of the
Yes,
website.
as good. He's right. I am not on that. You also kindly give me only 1 day's
I am taking your instruction. Please take down.
Yes,
Learned counsel appearing on behalf of the respondent state authority submits that the impugned vacancy has already been rejected by the order of the district level fair price soft selection committee. No, by order of the DDPS stroke DR. Accordingly, he submits that instant writ petition is liable to be dismissed as infructuous. Learned counsel for the authority has handed over the copy of portal.
Screenshot of the portal.
Screenshot of the portal. Let the screenshot of the portal be taken on record. Petitioner, next petitioner seeks accommodation. Upon the matter be adjourned to release the matter on 17.
As well as.
Also, this is by reply to the written opposition filed by the state respondent. Lordship, the petitioner has applied for MR dealer.
No, one application for addition of party is
Yes,
there.
one application. Why this application, Lordship?
Now, whether it was disposed of.
No,
No,
application
that
is
is why this
pending.
matter is
Lordship,
appearing under the heading application.
Today it is fixed for
It
hearing.
is fixed for hearing of the application.
Application. Applicant. Yes, you submit first. You are the applicant, you have to submit first. Today is fixed for hearing of the application, not the writ petition.
Yes, Lordship, the application, Lordship, filed by the proposed added respondent to that effect. That state has, Lordship, rejected my candidature on the ground that in presence of the proposed applicant, I have withdrawn my application.
You have?
Withdrawn my application.
The submissions, Milord, ought to be
Please,
made by the applicant.
Yeah, obviously. I'm just a sir.
Okay. Okay. Applicant, you submit the application.
Whatever you can say, but
No.
reality can be overruled.
What is your ground here? Who are you here? Whether you are interested party, then you have filed the application. I cannot understand your contention. What is the matter? You just tell me. This is a writ petition. filed by the petitioner, wherein the petitioner has prayed for some relief. He had challenged the selection of private respondent in this matter. Who are you here?
In fact, said application, two of the added respondent were added.
Is application.
That means that therefore, what is that? Two applicants do not find any application. Therefore, this application has to be filed for the month. And that again, the officer himself is by applicant, the application for action of party. Kindly see by the
Page number nahi kuch bhi nahi.
page 11 of my application.
Page 11 is your application is an Aadhaar card.
Application for additional party member.
Yes, can one is the addition of party. Aadhaar card, voter card's copy is there.
मिल नहीं है
You filed some copies of GD.
Yes, my lord.
3 copies of GD you have filed.
Yes, my lord. Lordship, kindly see first 16/5/2024 স্বাক্ষর জালিয়াতি করিয়া মহামান্য উচ্চ আদালতকে বিপথে চালনা করার চেষ্টা। Thereafter the GT has been written and they are submitted before the concerned officer in charge, Islampur Police Station. In fact, these persons never signed in any of the withdrawal application filed by the petitioner, and therefore this GD has been lodged before the concerned police station.
तो withdrawal application का opposition 25-26
Okay, now I understand. What is your name? What is your name?
My name is
What is the name of the added person?
my lord, at page 4 of the application, my lord. Mukhtar Alam. There are 3, my lord. Mukhtar Alam.
There are 3 persons.
The number 2, my lord, Ramkrishna Singh, and number 3, my lord, Mohammad Chaino. They are intended to be added as party respondents. Proceed.
Okay, this is your ground for addition of parties. Yes.
I have stated in paragraph 5, my lord. Paragraph 5 specifically I have stated. Page 7, paragraph 5. Kindly, please, my lord.
No, this is altogether separate issue. As your signature, one document was used in AO containing your signature, you want right to audience.
Yes,
This
my
can be,
lord.
this is your prayer.
I have specifically stated in paragraph 5, my lord.
What?
In my application, my lord.
You have never, that has to be come with an affidavit or otherwise, not by this application. This merit I cannot determine now. Okay. I want to, today I am just disposing of your application, addition of parties, whether you have a right to audience or not. This is the only question.
Kindly come page 25 of the affidavit in opposition.
Yes.
But I am not going to the merit, but why, Lordship, their presence is required, because I am supporting this application. Why their presence is required? Kindly come page 25 of the affidavit in opposition. The affidavit in opposition is this, Lordship, this affidavit. This is a neither notarized, not just a prayer, Lordship, written by the somebody. And according to them, this Ruksa Begum petitioner has put the signature in presence of the proposed added respondent. That is appears from page 26. Now, Lordship, according to them, from the averments of the application for addition of party, that they have not, Lordship, the witnesses to this signature of petitioner who has allegedly put signature withdrawing her application. They are not the witnesses.
That is altogether merit. I shall not pass any.
Now, Lordship, they have filed an application, they have lodged as journal diaries, and Lordship, their presence is necessary.
Okay.
Now, Lordship, this is my submission to that application.
In my affidavit in opposition, which was filed prior to filing of this application, I had taken a specific point, and before that, my lord, I had taken the specific point when I opposed the interim order before the learned single judge, honorable single judge. My lord, that the petitioner who is saying that this document annexed at page number 25 is a false document did not care to make parties, to make all the petitioners, all the signatories of that letter parties in the writ petition. And secondly, this alleged. If somebody continuously whispers, secondly, if the alleged document is forged and she has made representation before the authority as back as in September 2023, and the writ petition was filed in February 2024, heard in April 2024. My lord, she has not taken any steps before any law enforcement agency in the meantime to say that my signature has been forged in a document which has been used by the government authority. After, my lord, I made my submissions, after I filed my affidavit in opposition, after I disclosed my defense, my lord, this is a case only to better, this is an attempt only to better his case, my lord. My lord, I have categorically pleaded that an adverse inference should be drawn in my affidavit in opposition against the petitioner for not adding these persons as a party. Now, my lord, if your lordship adds this person as a party, this will not only better his case, this will not This will only improve his case, and for improving his case, my lord, these particular persons are making this application.
No, it is the law that the petitioner cannot improve his case on behalf of the opposition.
My lord,
It is the law.
that is what is
If they taken such plea, that cannot be
so
considered.
that is what is being trying to. That is what the petitioner is
I
trying to do,
understand,
my lord,
I understand.
indirectly.
However, you have some person appear before this court.
My lord,
They wanted to add as a party.
he is the dominant
I am
leader.
not going to the merit of this matter today. Only she wants the right of hearing.
My lord,
Very
In reply, Lordship, in
yeah, just wait.
That I, Lordship will decide that. Or not, but I will file a
Have you not filed anything? First time. You are the privatest one.
but can you?
no, Lordship, I oppose this.
That's why.
Yes, yes.
Yes.
Kindly
yeah,
record my
no, just wait. Yes.
We have raised some legal question and some facts that have been added by way of the candidate. But unless I dispose my defense to that effect, if I don't give
You want to file any opposition against CAN 1?
can one as well as to the writ.
No, CAN 1 you just submit today. I shall dispose of the CAN 1 today. I can allow you to file it in affidavit in opposition against the writ petition. What is your submission regarding CAN 1?
Can one my submission, but it is just correct. We say we are confused with the minor because we can say that we have signed some document, but I don't know whether that sign is this is the typical question of
Law and fact.
law and fact. But that
Very well. Well, that is the merit of the writ petition, whether it can be decided or not. But this is your objection. Yes, Mr. Mukherjee.
Lordship, the first, Lordship, what was my case in the writ petition? My case in the writ petition is, Lordship, when the result was published, merit list was published, the petitioner went to the office of the concerned authority, recruiting authority. Recruiting authority, all on a sudden, without issuing any notice, Lordship, kindly see any document from the opposition till date, not a single letter has been issued to the petitioner that this is the reason your candidature has been rejected. Now, this is the information derived from the office that this petitioner has withdrawn her candidature by issuing a letter. Now, Lordship, these averments I have made in the writ petition. That averment, Lordship, they could not substantiate in a single document. No, these reasons has been communicated to you that this is the letter that you have withdrawn your candidature. So, you have to challenge the same. So, Lordship, there was no scope to challenge this letter or to implead these persons or witnesses in the writ petition because in presence of them, I have put my signature. So, Lordship, at the relevant point of time when the writ petition was filed, neither they have communicated any letter, nor I have got any knowledge. Now, subsequently, Lordship, when the writ petition was moved, Lordship, they produced the document that this is the letter, the petitioner has withdrawn her candidature. Then this Honorable High Court directed them to file an affidavit in opposition. From the opposition, first time I came to learn that I have allegedly put my signature in this alleged letter in presence of the proposed.
Altogether, Mr. Mukherjee, you know, this is the new cause of action. You can challenge the entire
why this
action of the authority by a separate writ petition. Now this matter go out of the ambit of this writ petition.
No, Lordship, why their presence is required? Lordship, that's why, Lordship,
I have
they ought
understand.
to have made
Very
a
well,
party or not.
Okay,
Lordship, in this context, I'm submitting because at the relevant point of time, I had no knowledge. Neither they have communicated in letter, neither they have communicated.
So we have
this
to
alleged
communicate
letter.
somebody that you have withdrawn your candidature. You are communicated that you have withdrawn your candidature. This needs to be this needs to be communicated.
This is the merit I cannot pass.
And in an application, these points are being argued. I am not opposing. He is the dominant status in the writ petition.
Perpetrated for throwing me out from this, Lordship, the ambit of selection of this particular post.
Very well. Let's take down.
Conspiracy has been perpetrated.
No, that is the separate issue together. I will hear the matter at the time of hearing the writ petition. Okay. Can 1 of 2024. This is an application of addition of parties. Learned counsel appearing on behalf of the proposed party. The person learned counsel appearing on behalf of the applicants submit that they came to know from the petitioner that respondent authority has used affidavit in opposition against the writ petition, wherein some document was placed containing their signature. It is the case of the applicants that challenging their signature over the proposed document, they have filed general diary with the concerned police station.
Opposition reply can touch it.
It is the submission of the learned counsel for the applicant that the merit of the instant writ petition may be decided on basis of the document placed by the state respondent, wherein their signature is appearing. They crave leave, the right of audience, hearing of the writ petition. Full stop. Learned counsel appearing on behalf of the petitioner support the applicant. Next para. Learned counsel for the state respondent submits that the applicant are not at all necessary parties or proper party to the proceeding. This court has to determine the merit of the appeal irrespective of the document, irrespective of the sole document filed by the state respondent along with their affidavit in opposition. It is the further contention of the state respondents that the proposed applicant wanted to added as a party in this proceeding only to support the petitioner. It is the further contention of the state respondent that the stand taken by the petitioner after filing affidavit in opposition cannot be taken into consideration during the hearing of the in disposing the instant writ petition. First stop. Next para. Learned advocate appearing on behalf of the private respondent support the stand taken by the state authority. Stop. Having heard the learned counsel for the parties, it appears to me that the present applicants are never applied for the license. Moreover, they are unrelated to the proceeding, that is the writ petition filed by the petitioner. However, during the hearing, at the time of filing affidavit in opposition by the state respondent, one document was filed wherefrom it appears that the signature of the present petitioners are appearing. Admittedly, the applicant denied their signature over the document. Whether the signature over the document are correctly made by the applicant is beyond the scope of the writ jurisdiction. However, the document may be used for disposal of the writ petition. Thus, the applicant has the right of audience in the proceeding. Accordingly, the applicant may be not the necessary party of the writ petition, but they may be added as a proper party. Full stop. they may be added as a proper party. Full stop. Being the proper party, it is not necessary for the added respondent to file any affidavit. They have only right to audience of the writ petition. Audience of the hearing of the writ petition. Full stop. Accordingly, the Can 1 of 2024 is disposed of. Petitioner is learned advocate and record for the petitioner is directed to add the added respondents, add the applicant as added respondents in the memo of the writ petition within a week. Full stop. Next para, the learned, next para. Learned, private respondent intends to use affidavit against the writ petition. Let the affidavit be filed within 2 weeks. After filing an advance, after serving an advance copy to the petitioner and the state respondent. Let the matter appear, the matter is otherwise ready for hearing. Let the matter appear in the list on 11th of March for hearing.
May I file a short affidavit in this matter?
No, you being a proper party, you have nothing in the case. You have only right to audience.
Yes, great.
What's the evident reply kept to you? Evident reply I have filed. Let
You have filed the evident reply. Evident reply filed on behalf of the petitioner is taken on.
But at one place, your lordship was pleased to say present.
No, so I already served affidavit service before the court. Lordship, this is a long time hearing stage.
No, reply. Reply. He wants reply, copy of reply.
He has no right of reply because I have given a opposition against the reply against the opposition of the state.
When you have filed one affidavit, he is a party. He has the entitled to get a copy. You serve a copy. Yes. Next.
Lordship, kindly recall yesterday, my lord, I have argued almost at length, my lord. I pray for 10 minutes time to conclude my argument. And Lordship was kind enough to allow me, my lord. Lordship, kindly see, Lordship was kind enough to raise one question. What was the DAG number? Lordship will find from page 31. Page 31 at the top, DAG number is, my lord, LR 901.
Yes.
Lordship got it. In all document, I am not, my lord, showing all the document of myself, document of my father, document of my brother, the Porcha, ROR, and everywhere, my lord, LR DAG number is 901. Now, Lordship, I am drawing Lordship attention with regard to certain paragraphs of my pleading, just mentioning, my lord. Lordship, kindly take note, and Lordship, finally, my lord. Lordship, I am drawing Lordship attention, paragraph 3, paragraph 5, 6, paragraph 9, and paragraph 14. My lord, my frontage, my total area of land and everything. So, my lord, I am not reading all this paragraph in order to, my lord, complete my argument, my lord, within 10 minutes of time, my lord. Page 93 may kindly be looked into once again. Page 93, my lord, at the bottom, second paragraph, the impugned order which I have challenged.
Yes.
This is to inform you that Land Evaluation Committee visited the site offered by you, so and so date, and found the same to be not meeting the required norms as mentioned below, land not mentioning minimum requirement. Now I intend to hand over, my lord, the brochure. Lordship, kindly see page 28. When this clause is to be applied, whether it is on the subjective satisfaction of the authority, my lord, I have a right has been crystallized, drop, lot, I have been selected. Now, my lord, they are, my lord, in this manner, my lord, rejected my contention and right, negated my right in this fashion. Lordship, kindly come to page 28, middle portion, land evaluation. Lordship, got it?
Yes.
The concerned divisional officer, I am not reading. Evaluation of the offered land will be carried out to ascertain land being in advertised area and suitable for land of RO, recorded owner, meeting norms. The parameter under which offered land be evaluated by land evaluation committee for suitability. My lord, the question of evaluation to be done by the land evaluation committee, and this evaluation, my lord, cannot be, my lord, 2-3 word. rejection in 2-3 words. My lord, it must be objective, not subjective any manner. My lord, kindly see, lands fall within the advertised area. My lord, they are to ascertain it is within the advertised area or not. Land dimension meets requirement after leaving right of way line of the road. Land meets NHIAI norms for site of NH, National Highway Authority. My lord, here no such question. Land has no HT line, high tension line, my lord. These are the 4 criteria they are to evaluate, and they are to record their, my lord, the satisfaction in their official note, my lord. Land not meeting any of the above parameter will not be considered and will be rejected. Very good. But you intend to know which criteria my land fails to satisfy. Note, offered land should meet all the following: minimum frontage as specified in advertisement, minimum area as specified in advertisement, minimum depth. In case of offered land is found to be suitable, the LAC, my lord, letter of intent possibly, my lord, will submit the recommendation to the division and so and so. No, my lord, land evaluation committee, my lord, head for carrying out FVC, field verification credential of the provisionally selected candidate. If the case is not found suitable, the provisionally selected candidate will be informed. Information not by 1 line or 2-3 words, by resorting. Well, a number of words are available, my lord. Without, my lord, using all those words, my lord, it is not meeting the criteria. Which criteria? Whether all the criteria, whether one or all, then, my lord, that being the situation. Apart from this, my lord, I intend to draw lots of attention with regard to the brochure, page 25. Page 25, lots you will find things to be done. My lord, they have decided one after another steps to be taken. At the bottom, my lord, Roman 10. In case of rectifiable deficiency in the document submitted, intimation to the provisionally selected candidate to submit the required corrected document within 21 days. Then, my lord, what are the rectifiable documents? I am coming, my lord. Lordship, kindly come to, my lord, page 27. Final processing in the middle portion, lordship. Lordship, got it? Of application of provisionally selected candidate and documents to be submitted by the provisionally selected candidate before FVC. My lord, the field verification credential. Then, my lord, first paragraph, kindly skip. Second paragraph, then document applicable for all categories. My lord, notarized affidavit by the applicant, proof of age, proof of educational qualification, appendix, consent for offer of land if applicable. Here, my lord, consent is applicable. I have given consent by a notarized form. The prescribed format is available with this brochure in appendix. I have filled it up and submitted and uploaded to them. So, my lord, these questions are relating to the land question. Other question, they did not raise any question. They have raised question with regard to land. So, my lord, copy of land document in support of ownership, lease rights, sketch site map, offered land with dimension. So, my lord, that being the situation, then lordship, kindly come to page 29, middle portion. Field verification of credential, 15, will be carried out for the provisionally selected candidate in respect of the details given by the candidate in the application form. The objective of FVC is to verify the correctness of the details given by the candidate in the application and the document submitted thereafter. Failure to present this document in original at the time of field verification can result in cancellation of selection. That was not their case. I failed to, my lord, produce all the document when field verification taken place. Intimation regarding FVC will be given to the provisionally selected candidate within 10 days. Where is that intimation? Then, my lord, skipping that paragraph, in case of no response, no availability of the provisionally selected candidate, it should be cancelled. Then, my lord, the candidate would be required to produce all original document. Then, my lord, last paragraph, original affidavit, copies of which are uploaded, would be required to be submitted by the candidate to the field verification committee, credential committee. So, my lord, this was not their case. They did not indicate why this, my lord, is not meeting the criteria, which portion is applicable so far myself, whether it is a rectifiable mistake or not. No indication, nothing of this sort, only 1 or 2 lines without hearing me, hanging me. My lord, our humble submission, hear me, then hang me if situation so warrants. Then, my lord, kindly come to page 33. Here, my lord, paragraph 23, list of non-rectifiable deficiency in application. So these are the non-rectifiable application. So whether my case is within the four corner and ambit of this 23, that is also a question which is cropped up in my mind, haunting me, my lord. That being the situation. Affidavit in the bottom, my lord, affidavit appendix 3 is of late data dated of application, no alteration, addition, deletion of the application will be permitted.
So what you want in this is,
But I want, definitely, my lord, the position is to be restored. If not, my lord, I am ready and willing, kindly appoint any person of this Honorable High Court to go there and to measure and to come to a conclusion whether we are making a submission before this high prerogative writ jurisdiction in a constitutional court based on, my lord, lie, untruth story. We are even in a position to go there. Myself is, my lord, graduated and master degree holder of the, my lord, the Gaurbanga Vishwavidyalaya. My lord, I have that qualification. I am unemployed youth. I am in search my profession. And they have selected me. Some fairness was there, as a result of which I have been selected. Now, my lord, suddenly they have done it. And, my lord, hanging me in this fashion, which cannot be permitted in any manner whatsoever.
that means you do not know what is the reason for.
No reason.
So
That
you
is
want
why,
to
my lord.
know the reason.
Reason. That is what, my lord. I am praying, my lord. Even this honorable court, my lord, they put someone of our honorable court to go there and to measure and to come to a conclusion and to file a report. We are ready and willing, my lord, to pay the amount for the rendered advocate. That being the situation.
What do you know? Your measurement is incorrect or
No,
then why you are
absolutely.
so-
Then, my lord, I am just making.
No, no.
Sometime,
why-
then, my lord, I
Okay.
intend to rely on judgment. Then, my lord. Juleka Vidyarthi, lordship knows it very well. Only one paragraph, my lord. I am just reading and handing it over. Citation হচ্ছে 1991 1 SCC 212. 1991 1 SCC 212. 36 paragraph, my lord. Just a building, my lord, and then you hand it over and I'll conclude my hearing, my lord. I think it is within, my lord, this 10-minute time. 36, why the meaning and true import of arbitrariness is more easily visualized than precisely stated or defined. The question whether an impugned act is arbitrary or not is ultimately to be answered on the facts and circumstances in a given case. An obvious test to apply is to see whether there is any discernible principle emerging from the impugned act, and if so, does it satisfy the test of reasonableness? Where a mode is prescribed for doing an act, there is no impediment in following that procedure. Performance of an act otherwise in any manner which does not disclose a discernible principle which is reasonable may itself attract the vice of arbitrariness. So Lordship knows it, well accepted, universally acknowledged, and that being the situation, my lord, this paragraph 36 of 1991 1 SCC 212, I'm referring, my lord. And
No, now you cannot argue on that point. They have acted arbitrarily or like that.
Not.
They have served a cryptic.
That is why this is arbitrary, my lord. Reasonableness must be there, yardstick must be there, Witnessbury yardsticks are there.
Only this point you are arguing.
Yes,
on.
this is my.
Yes, Mr. Chakraborty.
Yes, my lord, firstly comes to the application at page 19, my lord. Starts from page 19.
Yes.
And page 20, my lord, the details of the land, that is item number 13. 2 lands were offered, my lord. Plot number 1 does not mean Dag number, my lord. 2 separate plots were offered, and he admitted that. I will come to that. That particular letters were not brought into the record in the writ petition, my lord. Arif Mia, and he has specified Khatian number. Your lordship will find from the column, my lord, 3449. And the measurement has not specified. That will come from the record of rights, my lord. And the deed that was referred to and relied upon annexed, that is a joint ownership, my lord. The brothers, along with Mr. Arif Mia, purchased the same jointly, and his share has been correctly recorded in the record of rights. Now, your lordship, second, Arif Mia has offered his father's land, that is plot number 2. Plot number 1 is one land, and plot number 2 is another land. Apart from that, nothing has been given, my lord. So far as the format does not prescribe that plot number 1 and plot number 2 to be merged in a single land, to be treated different. I will show you from the brochure itself, my lord, why this is done, my lord. Now,
So plot
admittedly,
number 1 mean for the go down.
No. This is not LPG, my lord. Your lordship kindly sees this is retail outlet, petroleum.
Yes.
So there is no separate for godown and showroom.
This is retail outlet.
Yes.
Okay.
Only a single land petrol pump.
Petrol pump.
So one is plot number 1 and another is plot number 2.
Two plots have been
offered, my lord. Either this one or that one. Plot number 1, he has specifically referred to 3149, that is the Khatian number. And so far as plot 2, he has referred to 854, my lord. That is the Khatian number, one pertaining to the applicant himself, that is the first one. And the second one is his father. No details have been provided regarding his other brothers, that is the co-sharers or co-owners of the plot of land by which he purchased the same, my lord. May I? Now your lordship kindly comes to, for clarifying, comes to the record of rights, that is as page 61, my lord.
Yes.
That is the petitioner, Arif Mia, and the 901, very well. 901 is the plot number, and his share is, he is owner of 13 and odd decimals. That is 0.13 acres, means 13 and 40 decimals, my lord. Now, this particular plot of land, quantum of land, is not sufficient to meet 25 into 25, what he has stated in the application. I will place, my lord. This is at most 526 square meters, not 25 into 25, 650 square meters. Much below that. Now, your lordship kindly, before traveling further, my lord, may I just, lordship already is having the copy of the brochure, my lord.
Yes.
May I just please indicate? Page number 9, my lord. Internal page 9. Internal page number 9. There is note 1. There are two notes. Note 1 in the middle. And thereafter B. It states, if an applicant offers more than one land, then a confirmation in writing is to be obtained by the land evaluation committee.
You are reading?
Page number 9, internal page number 9.
Note A, B.
B.
B. Yes. Yes.
If an applicant offers more than one land, then a confirmation in writing is to be obtained by land evaluation committee from the applicant with regard to the plot of land to be considered for evaluation. So he has offered two pieces of land, either this or that. Had it been a total in a consolidated form, the Khatian numbers would have been mentioned in one lot only. He has stated in plot number 1, although the format, I will show you, format does not prescribe that he will mention it as plot number 1 and plot number 2. Whatever quantum of land he had to offer, he has to offer in a single way, this Khatian number, this Khatian number, this plot number. That was not done. Apart from that, what is his own submission? That it was asked that which plot you want to provide. And what is his reply to that? Now, this was written prior to field verification, that is on 15th of July 24. May I read and thereafter hand it over, my lord, with a copy to you also. With reference to your application number such, I have received your email for LEC. I have offered two plots in our, I have offered two plots. May I just, I have copy. May I just place, my lord, with reference to our application number such, I have received your email for LEC. I have offered two plots, kindly records that. Two plots in our application as detailed below. Plot number 1 specifically states Khatian number 3149, such and such. Plot number 2, Khatian number such. Both above plots are in village, Faridpur. I cannot read, Manad, Domutha, etc. plot number 1, the last 4 lines is the most important. Plot number 1 location is situated on the left side at Tajto Kumarganj Road, which is constructed with the block within the block Gangarampur to block Kumarganj. Now the next, hence I request you to kindly consider plot number 1 for evaluation to opening my petrol pump. So he has voluntarily said that he want to restrict his petrol pump to be operated from and LEC to be conducted with regard to plot 1 only. Now plot 1 has been offered. He has specifically mentioned a particular Khotian with regard to that plot. Now I will place for your lordship the field verification, whether he was aware of the same. It was in his presence. Now your lordship turns to next page, second page, my lord.
Permit of land evaluation by LEC.
Yes, my lord. This is the committee who visits. Now, second page, in the second row, my lord, your lordship will find candidate has offered 2 plots. However, both plot does not meet minimum area as specified in advertisement. This was the specific finding, and that has been signed by the petitioner also. In the next page, your lordship comes. This has been signed. Arif Mia's signature appears there. Now your lordship kindly comes to the last page of the report. There is the sketch map.
Yes.
And offered plot number 1 on the left hand side and offered plot number 2 on the right hand side. Measurement is there. On the front portion 25 meter, depth 30 meters, taking totality. However, he chose to restrict himself only with regard to plot 1. Now the remarks, candidate has offered 2 plots. However, both plots does not meet minimum requirement area individually. So either plot 1 or plot 2, if taken independently, does not satisfy the minimum requirement. May I sum up that he offered 2 plots, 2 separate plots. He himself said that I want to restrict myself within plot 1. And LEC was conducted with regard to plot 1 only. Plot 1, there was a deficiency. That's why his candidature was rejected. Now, your lordship kindly comes to, that has already been placed, land evaluation, that is the page 28.
Page 28.
Last 2 lines. 2 lines.
Yes.
Land not meeting any of the above parameters will be considered and will be rejected. Offered land should meet all the following: minimum frontage as specified advertisement. The words minimum are used. These are the minimum requirements. For that particular word, the word minimum has been used. Yes, there are several languages or words in English, but whether he understood, he was present in the field verification during the LEC, and he accepted the same. That I have placed the field verification report or the LEC report, where he made his signature with the observations. Your lordship will see.
Yes.
Arif Mia's signature appears there with comments, remarks. Top right hand portion, there is the remark, and the bottom right hand side, the signature of Arif Mia. So he has accepted the same. He was aware of the same, that the minimum requirement did not fulfill at that material point of time of inspection. Now your lordship kindly comes to page 30 of the brochure.
Yes.
The last, there is a grievance redressal system. Any complaint should be accompanied such and such. Now, my intention is that he can place this contention for reevaluation or whatever before the appropriate authority for evaluation or whatever. There is grievance redressal system itself. And next page, that is page 4, not 4, item 4. On receipt of the complaint, a letter will be sent by the oil company to the complainant through a registered speed post asking him to submit details of allegation with a view to prima facie substantiate the allegations along with supporting documents. If within 20 days from the date of dispatch of letter, while
No, this is in respect of the complaint against the
file complaint.
against the selected candidate.
No, no.
Whether
any-
by the selected candidate?
himself, rejection, any sort of complaint. It's
Any
not
sort of
that,
complaint?
yes,
The anonymous complaint.
Any complaint.
yes, the petitioner could have also preferred an application before grievance redressal system, my lord.
No, selected candidate means the candidate who has completed field verification of credentials successfully. And it-
Selected candidate means the candidate who has completed field verification of credentials successful and is eligible for issuance of
Yes.
LOI.
That is the issue.
Huh.
He has not completed the field verification.
Yes, but prior to that, general complaints with verifiable facts, complaints against selected candidates. Now there are two.
General
General is there also.
variable facts.
Now your lordship kindly comes to page 37 of the brochure. Internal page 37.
Yes.
This is the format, application for retail outlet dealership format. Now your lordship kindly comes to serial number 13, that is at page 39. This is the format on the basis of which he has submitted the application. Now item number 13 provides details of the land, name of the owner of the land, leaseholder, etc., etc. Where is the provision of differentiating plot number 1, plot number 2? He has offered two lands, mentioning it as plot number 1 and plot number 2. Either this one or that one. That I have showed.
Not jointly.
Not jointly. And I have showed the brochure specifically provides at page 9 that if an applicant offers more than one land, then a confirmation in writing to be obtained by the land evaluation committee. That was asked. He, through his letter, opted to
plot number 1.
Plot number 1. Then where is my mistake? How did I acted arbitrarily or malafide intention? That has to be proved from the documents itself before passing any interim order or proceeding further. Now your lordship kindly sees, comes to page just for a moment, my lord. Now, at one stage, he has stated that he has offered 3 khatyans. But however, the last khatyan, that is in the name of his brothers, were never uploaded, nor submitted, nor indicated or mentioned in the application. Now, the order of rejection, my lord, so far as at page 93, land not meeting minimum requirements. Minimum requirements I have indicated. And he was aware of the fact that the plot number 1, what he intended to offer, did not meet the minimum requirements, man. Now, your lordship kindly sees that I want to bring all these documents on record, my lord. If your lordship permits, I can file my affidavit in opposition, my lord. But as on date, so far as prima facie case is concerned, there is no scope of passing any interim order, my lord. Since he has suppressed his own letters in his writ petition, my lord, with an unclean hand, there is no arbitrariness in view of the fact he has in his own letter admitted that he want to restrict himself within plot number 1. That was evaluated. That particular inspection has not been challenged, my lord. Now he comes up with a different story that he has offered or filed appendix, but he has to mention the same. He has relied upon, sure, but he has not mentioned the plot khatyan numbers. And subsequently, my lord, he has confirmed that he want to restrict plot number 1. And plot number 1 in his application refers to his khatyans only, khatyan only, my lord. Your lordship kindly either disposes of or gives me an opportunity to find my affidavit in opposition to bring on record all these documents, my lord.
Yes. My lord, my learned friend has, my lord, relied upon a document just handed over to me. Lordship, kindly come to the document. Though my learned friend is laying emphasis that I have offered only 1 plot of land, in terms of the, my lord, the form itself, there are, my lord, kindly come to page 21st. Then, my lord, I am coming to his document which has been supplied to us.
Yes.
My lord, at the top, lordship, there are name of the owner of the land lease holder, relationship with applicant, so and so. Then, my lord, location. Then, khosra number, khotiyan, GAT number, survey number. Then, my lord, I have indicated to khotiyan. Plot number, it means dag number. My lord, plot number here means, my lord, I am offering 2 plot of land, one for myself, another for my father. And the provision is there in the, my lord, the oil company's provision, they including further and near relational land to be taken into consideration for the consideration. I have offered 2 plot of land. It means, my lord, khotiyan is 2 separate khotiyan, but plot 1 same identical. The stretch, if lordship kindly see, my lord, deputing someone, my lord, meet every criteria of the oil company. This is one aspect. The other aspect is other aspect is, my lord, if, my lord, the record of right which I have enclosed, lordship will find the khotiyan number different, but dag number is 901. In deed itself, my lord, schedule dag number is 901. Khotiyan separate. Here they have indicated to disclose khotiyan number. I have disclosed it. Then, my lord, what happened?
You have not disclosed. You have disclosed the khotiyan number.
Yes, well, kindly see the headline. Khosra number, khotiyan, GAT number, survey number. My lord, in that particular column, we have indicated the khotiyan number. There is no dag number provision, as a result of which, my lord,
No,
skipping.
you have mentioned in the application plot number 1, plot number 2.
No, that is plot number 1 belongs to me, myself, self. Kindly see. In this portion, it is written self. And the second portion, it is written further.
So you have mentioned plot number 1 and plot number 2.
It doesn't mean, my lord, dag number is separate.
Plot number means the plot number is there.
Plot number means 1 belongs to my father.
So whether you are intends to the joint plot?
Yes, my lord.
So what is your intention?
My lord, the intention I am showing. It is intention reflected from their document. They have considered both the plot. I am showing my. Then my lord kindly
No,
examine.
you have offered only plot number 1.
No, at the same time my father's land, and then my lord kindly see, thereafter lordship will find the above piece of land owned by me, my family member, as clause number so and so, either by way of ownership, long-term lease, would be made available for a period as per the terms and condition of the advertisement published by the oil company so and so. This portion is there, as a result of which I have offered this land. Then my lord see their document itself, the document which they have handed over. Turn to the next second page. Offered plot suitable for development of so and so. They have written no. Then my lord, if offer land is not found suitable, detailed reason for non-suitability of the land. Their document, my lord, page 2. Their document, page 2. Yes, you've got it?
Yes.
In the box they have written, candidate has offered 2 plots. So they have accepted 2 plots. Plot means not Dag number. It means piece of land. However, both plot does not meet the minimum area. So altogether, whether it is meeting the minimum criteria or not, that to be taken into consideration. They have taken into consideration both the plot. Once again, I am reading. Candidate has offered 2 plots. However, both plot does not meet minimum area as specified in the advertisement. So our humble submission, let an inspection be made, whether it is meeting the criteria or not. Then, my lord, what is more, detailed reason for non-suitability of land. My lord, the brevity is the wit of art, we know, my lord.
No,
But this kind of brevity.
You are not going to the properly.
My lord, then, my lord, this kind of brevity.
You see your application.
Yes, my lord, once again.
Page 20.
20.
You have offered 1 plot.
Yes.
Plot number 1.
Self.
And plot number 2.
2.
So
Doesn't mean 2 separate Dag number.
No, I understand.
Lordship.
Forget about that.
Lordship.
I understand. You have not offered the Dag.
Yes.
You have offered the Khotian number.
Yes.
And you have mentioned in the plot number 1,
Lordship,
your frontage area and depth area.
Yes.
These are incorrect.
This is one. The other is, my lord, my father's land is.
These are incorrect.
This is what is more, my lord. My father's area is also there. That to be also taken into consideration. My lord, they are not taking this particular plea that I have practiced fraud, misrepresentation upon them. This is not their case. Yes, my lord, I am well aware. This is not their case, my lord. I have practiced fraud. Land altogether does not meet the criteria.
What prevented you to offer both the land?
My lord, I have offered,
No,
and they
you
have
not offered.
My lord, they have considered it. Kindly see.
No,
Once again, I am reading.
This is your application on 15th of
At the
July.
same time, my lord, maybe some the misunderstanding is my learned friend is
Can
trying
you
to
say
clear.
there are some misunderstandings
No,
that I can
but kindly see, my lord, kindly see. Candidate has offered 2 plots. So, my lord, they have accepted. Then, my lord, however, both the plot does not meet the minimum area. Whether both the plot does not meet the area or not, that to be decided by this honorable court. Kindly see, this is their assertion. They have asserted it in the box, lordship. Next, my lord, next page, my lord, lordship, see.
Yes.
Even if I have committed wrong, they have, my lord, rectified my wrong and they come to the conclusion within the box.
They
And
have
this
no
is not,
authority to rectify.
no, my lord, if that be so, the different question altogether. I think, my lord, they have considered both the land and come to a conclusion arbitrarily. And my lord, in the offered land is not found suitable. In the box, there are provision of detailed reason. Where is the detailed reason? In the event detailed reasons it's supplied, I can challenge it. My learned friend referred Grievance redressal forum. My lord, before appellate forum, I am to deal with the order of the my lord, the lower authority. Where is the order? Does not meet requirement. So, my lord, I am to go there and to, my lord, challenge it, even if I am assuming that is a appropriate forum for my appeal, not to come before this honorable court, but to the redressal forum. That is also, my lord, the order is not appropriately made, cryptic, arbitrary. Then, my lord, what is more, lordship, kindly see, my lord, the sign, signature. I have made my signature. They requested me, but if I sign before a police authority, tomorrow it will be admitted against me, my lord. I have signed, but some sort of, my lord, they have requested me, I have signed it. Whether I have accepted, meaning my signature is there, it means I have accepted it. Never, my lord, cannot be waived in this fashion in any manner whatsoever. That being the situation. Then, my lord, appeal issue, my lord, I am dealing with the appeal issue. And my lord, I have enclosed the consent of all the parties in terms of the brochure. So both these two land, my fatherland and the land of mine, to be taken into consideration by the authority. Land is same, my lord. I'm repeatedly saying, Khutian is different, land is same. Once again, I'm repeating, and they have taken into consideration because land valuation credential committee went there and come to a conclusion, both the land are same and identical. That is why they have written this particular portion. Now, my lord, let them direct to file a fresh report, whether both are same and identical or not, or my lord, they put someone, we are ready, my lord, and then we'll out, my lord. After the report is filed before this honorable court, we are out.
No, you just, you have to satisfy this court.
Lordship.
Why you preferred the two numbers, plot number 1 and plot number 2?
It means not
I
dark number.
understand.
My lord,
Later confirming plot number
my lord,
1.
kindly see at the top, it is written Khosra number, Khotian number. I have indicated Khotian number.
I understand there is
True.
a single plot.
True.
There are documents.
So
that there is a single
So
plot.
man may lie, my lord, paper cannot.
And you
Let-
come with that.
Let my lord,
Properly that I am
let-
made some mistake
my lord,
at the time of offering.
let the authority be permitted or directed to rely upon the document and field verification report. Document is lying with them. I have uploaded each and every document. And if any mistake is committed, for that reason, my lord, my right will go.
That you are admitting that you have made a mistake.
No, my lord,
You
as
will not admit
it appears, there is no column of plot number 1 and plot number 2, so far their brochure is concerned. Possibly, my lord, upon certain, my lord, the misguidance and all these things, they have done plot number 1 and plot number 2.
You have done that.
No,
You have done- they
this
have not.
form has been filled up by the person itself, my lord. I am to take instruction. So far that part, I am to take instruction. So far that part is concerned. Even if, my lord, that is there, that minor mistake is there. For that reason, my lord, the plot is same and identical. And my lord, whether it meets, my lord, the criteria or not, that to be ascertained by the authority, my lord. Let that direction be given. Then if I have committed mistake, I will go out, my lord.
Unless it is a rectifiable defects, cannot be. That will violate Article 14, my lord.
Field,
not relax.
Field verification committee is the body of the expert. Let their, my lord, the observation be directed to be produced before this court. Only 2 line, half line, my lord, cannot. Lordship knows, my lord, some, my lord, extraneous factor are, my lord, playing vital role everywhere nowadays, my lord. Nowadays.
What prompted you to sign this letter? That I am offering
My lord,
only one plot.
my lord, inspection is taken place. They are requesting me to sign. I am signing it. My lord, before police authority, my lord.
This is a handwritten letter.
It means
Whether
that
you are denying this letter.
no, my lord, kindly consider, my lord, they have, my lord, leaving everything, my lord, a box portion may kindly be looked into. Here, my lord, candidate has offered 2 plots. However, both the plot does not meet minimum requirement. Whether that is true or incorrect.
Yes,
Lordship,
both the plots are meeting not required the
my
criteria.
lord, here, that is
Both the plot meets both the plot individually.
our humble submission may kindly be looked into, my lord. If I am not a owner of a particular land, and my lord, with the help of the land of my father, I am not filing this particular application. My land along with the land of my father, both they have taken into consideration. And my lord, this cryptic, my lord, note is there, though detailed notes is required to be recorded here. Here also cryptic note.
No.
Yes, my
Why
lord.
you are saying so?
My lord, the brevity is the weight of art.
According to the brochure, they have asked you what plot you want to use.
Yes, my lord, I have indicated.
You indicated plot number 1.
Not dark number.
What prevented you to indicate both the plots?
Plot same, my lord. Plot 1, plot 2.
No, you have separated it, plot 1, plot 2.
Allow me, my lord, to take instruction as to why this has happened, whether it is a mistake or not.
Such arguments, my lord.
Tomorrow itself, my lord, whether they have, my lord, out of mistake they have done it or not, I'll admit it, my lord.
They cannot be allowed to take advantage of the situation. They have not mentioned the same in the writ petition.
So this is a
even
it is a mistake that cannot be treated as
that
serious.
is not a rectifiable mistake. Let them show. They have referred to the clause of the brochure. The rectifiable mistakes are there.
My lord,
Let them show.
We wrote letter addressed to them, my lord. That was still remain unaddressed. That is still with them, my lord.
Coming for a consideration order. So let them consider.
No, my lord, not consideration order.
They have been done in the very
Even, my lord,
instance.
my learned friend indicated the appellate forum is there. Reason order is not there. What order I will challenge, my lord? There must be an order, my lord. For that reason.
For that. Did you ask for that?
My lord, 1 line 3-4 words, my lord. A particular order is, my lord. My right is curtailed in this fashion. Our humble submission, both, my lord, they have taken into consideration both the land.
And
now, my lord,
they are not out of the game. They will be In the group 3 stage, they will be entitled to offer the land subsequently. That is in the requirement brochure, my lord. It is not that they will never be considered. Your lordship kindly comes to
Yes, according to the brochure, they can offer another land.
no. That is another thing, my lord. That is not the alternative land. There is no scope of that. But there is a scope, my lord. I will indicate, my lord, in the brochure. But that pertains to the LPG, my lord.
Okay, I am just confusing.
Yeah, my lord, very well. Your lordship kindly comes to page 5, my lord, of the brochure.
Yes.
Group 1, applicants having suitable piece of land in the advertised location area, either by of ownership or long-term lease. This is group 1. Now, petitioner is group 1. Group 2, applicants having firm offer of suitable land. And group 3, applicants who have not offered any land. In case, now the last, in case land offered by all the applicants under group 1 and group 2 is found not suitable, not meeting requirements, then these applicants under group 1 and group 2, along with applicants under group 3, would be advised by OMCs to provide suitable land in advertised location within 90 days. So he is not out of the race. He will be treated as a candidate under group 3 and will be asked to provide alternative lands. The moment group 1 and group 2 are out, we don't find any suitable candidate. So it's not that you need not consider this, since there is no case made out in the writ petition, but to indicate that
that is only applicable for the SC/ST candidate. Group 3.
Group 3 only under
SC/ST category. Then I am general category. So that is a different question altogether. What my learned friend is indicating, appeal question, group 3 question, that's a different question. There is no appellate forum. That is why we are before here. And there is no reason order to, my lord, challenge the order before the appellate forum.
There is no appellate forum. There is a grievance redressal forum.
Oh, my lord, grievance redressal forum cannot be the alternative of appellate forum. And there is no order at all. How to challenge it, my lord?
Anyway, we have admitted that restricting to plot number 1.
Okay.
Lordship,
Okay, please take down. Petitioner applied for grant of rural retail outlet of petrol pump in terms of advertisement issued by the respondent authority through daily newspaper Anandobajar Patrika dated 18 July 2023. Petitioner has made an online application containing details of land he wanted to offer. Full stop. Vide letter dated communication dated December 1st, 2023. The respondent authority informed that the petitioner have been qualified for draw of lots for the selection of RO dealership. did one communication dated 10th July 2024. The respondent authority has informed the petitioner that Land Evaluation Committee within bracket LEC will visit the site offered by the petitioner at the subject location for inspection, and petitioner was requested to present personally along with his photo ID card at the offered site on 20th July 2024 along with relevant land documents. However, the date of inspection was later cancelled and it was refixed on 25th of July 2024. Thereafter, on 18th of November 2000, the inspection was done at the cited location on 25th July 2024 by the Land Evaluation Committee. Full stop. Thereafter, on through an communication dated 18th November 2024, the respondent authority has communicated that কি বললাম বলুন? Through impugned communication dated 18th November 2024, the respondent authority has communicated as follows. Page 93. Page 93 of writ petition. Mark portion. Page 93. Being agreed by the said communication, the instant writ petition was preferred. Instant writ petition is preferred for quashing of the said communication. It is the contention of the learned counsel for the petitioner that the petitioner is a most suitable candidate who offered the land for construction of retail outlet of petrol pump. The field verification committee has inspected the site and erroneously came to the opinion that land not meeting minimum requirement. Land not meeting minimum requirement. Land not meeting minimum requirement. Full stop. Double nuko. Learned counsel for the petitioner submits that the cryptic communication of the respondent authority made the petitioner surprised why his candidature was cancelled. Accordingly, he made one representation with the authority on 26th of November 2024. His representation was not at all considered. Hence this writ. Next, it is the contention of the learned counsel for the petitioner that the impugned communication is a non-speaking order, wherefrom the reason for cancellation of the candidature cannot be ascertained. He further submits that cannot be ascertained. Full stop. He further submits that the act and action of the competent authority is beyond doubt. They have straightway negated the prayer of the petitioner, who is a most suitable candidate, having sufficient measurement of land for establishment of retail outlet of petrol pump in the advertised location. It is the case of the petitioner that the impugned communication may be set aside and the petitioner may be allowed to continue to the procedure. In support of which contention, learned counsel for the petitioner has cited a decision of Honorable Supreme Court reported in Kumari Srilekha Vidyapith and others versus State of UP. Within bracket 1991, one Supreme Court cases 212. Learned counsel appearing on behalf of the respondent authority submits that from the application of the petitioner, it would be revealed that the application that the petitioner has offered 2 plots of land by citing as plot number 1 and plot number 2. Full stop. According to the Brochure, when a candidate offered more than 1 plots, the authority concerned has put the question to the petitioner which plot he intends to offer. On such query, the petitioner himself read a letter dated 15/7/2024 has informed that though he had offered 2 plots of land, but he intends to offer the plot number 1 for evaluation regarding opening of petrol pump. On the request of the petitioner, the land evaluation committee has visited the site and visited the site in presence of the petitioner and came to the opinion that the offered plot number 1 is not meeting the required criteria. The plot number 2 also not meeting the required criteria. Accordingly, they have issued the impugned memorandum containing the term that within inverted comma, double inverted comma, land not meeting minimum requirements. Full stop. Learned counsel for the respondent authority submit that the act and action of the authority is according to the procedure laid down in the brochure itself. They have followed the procedure according to the full stop, according to the request of the petitioner. They have only used the plot number 1 for the purpose of establishing retail outlet of petrol pump. He further submits that the application itself stated the 2 plots. Thus, the authority concerned has acted accordingly. Learned counsel further submits that if there is any complaint, if there is any complaint, the petitioner may approach before the concerned authority who can redress the complaint. It is the further contention of the respondent authority that the instant writ petition has no merit to entertain. No merit to entertain. Having heard the learned counsel for the parties, it appears to me that the petitioner has offered through his application, 2 plots of land, being plot number 1 and plot number 2. Admittedly, plot number 1 has mentioned the Khatian number 3149. That is the LR Khatian number of the petition. And plot number 2 contain Khatian number 854. That is the LR Khatian of father of petitioner. Full stop. Both the Khatian, no, LR Khatian of a person, LR Khatian of a person may include several plot numbers. Full stop. However, for purpose of better reasoning, it can be ascertained that both the Khatian numbers has mentioned a singular plot. That is LR plot number
901.
901. Full stop. From the report of the land valuation committee, it appears that plot number 901 contains several Khatians. The LR porchas, which was annexed with the writ petition, also pointed out that same plot of land was included in several Khatians, that is Khatians of the petitioner and other brothers. Khatians of petitioner and other Khatians of his brothers. Full stop. According to the brochure, the concerned authority has asked the petitioner which area he intends to use as establishment as establishment of retail outlet, he unequivocally has offered only plot number 1 and mentioned that the plot number 1 is located stroke situated on the left side of the passenger of left side of the road, full stop. Left side of the Pransagar to Kumarganj road. Pransagar to Kumarganj road, full stop. A site plan within bracket not measures to scale, not measures to scale, bracket close, is appended with a document placed by the learned counsel for the private respondent, wherein it appears that plot number 1, offered plot number 1 and offered plot number 2 are contiguous plots, are contiguous and are of a singular plot of land, that is LR plot number 901. LR plot number 901, full stop. The petitioner has not offered the entire plot of land, that is LR plot number 901, but he has particularly offered plot number 1 as appearing in his application. So admittedly, the authority concerned has acted upon the undertaking and request of the petitioner for measurement through land evaluation committee, full stop. Thus, it appears from the measurement, it appears that the area of offered land, offered plot number 1 is less than 625 square meter, and offered plot number 2 is also of area less than 620 square meter. In the application itself, though the petitioner has mentioned that both the offered plot numbers meeting the frontage in meter 25, both the offered plots are of area of 620 square meter, but during inspection it appears that both the plots are not meeting the same criteria. However, it is true that both the offered plot may jointly meet the required criteria, but as the petitioner has offered only plot number 1, so it is not obligatory for the respondent authority to consider both the plots, that is both the plot numbers, that is plot number 1 within bracket Khatian number 3149 and plot number 2 within bracket Khatian number 854 for evaluation under the land evaluation committee. On that score, it appears to me that though the petitioner has approached the authority with 2 plots of land, but at that but before the field verification, before the land evaluation, by LEC, he himself offered only plot number 1. I find no justification. No, I find no arbitrariness in the action of the petitioner and in the action of the respondent authority. Next para, though the impugned communication appears to me very cryptic in nature, it has not assigned any particular or detailed reason for cancellation of the for making the comment that candidature has been found ineligible, but as it appears that the petitioner was all along present at the time of land evaluation. So I am of a view that the petitioner must have well aware about the fact. However, the concerned authority has the opportunity to consider. Now, concerned authority may consider the prayer of the petitioner if it is within their jurisdiction. So at this juncture, I think it necessary to pass an order so that the authority concerned may dispose of the representation of the petitioner on 26/11/2024. Representation of the petitioner dated 26/11/2024 with a written order. Full stop. I make it clear that I make it clear that this court has not entered into the merit of this matter. The authority concerned is at leave to dispose of the matter according to the law within a stipulated time. Full stop. The instant writ petition is disposed of, directing the competent authority to dispose of the representation of the petitioner dated 26/11/2024 within 8 weeks from date. Within 8 weeks from the date, after giving a reasonable opportunity of being heard to the petitioner. After giving a reasonable opportunity of being heard to the petitioner. Full stop. The present order of the authority shall be intimated to the petitioner within 2 weeks thereafter.
The
disposed of.
That the authority may not be swayed by the observation made by this honorable court may kindly be recorded, my lord.
Okay. I have already make it clear.
My lord, kindly, my lord, specify it.
Okay. I have not, this court has not entered into the merit of this matter.
That has been specified.
Yes.
And not to be swayed, my lord.
Okay, okay. Entered in the merit of this matter. The authority concerned is at leave to dispose of the representation according to the law without being influenced by any observation passed by this court.
And my lord, at the same time, my lord, allow us to file a supplementary representation before the authority, my lord. If we because of this document they have produced before us today itself, my lord, that liberty may kindly be given. My lord.
With the office, they can ask for.
No, my lord, the
opportunity of being heard means everything.
Yes, my lord. My lord, allow us, my lord, to file a supplementary representation. One line may kindly be given, my lord. Heaven will not.
Opportunity of being heard means all document.
Now, only direction was there, my lord, to consider the representation. They may confine to the four corner of this representation. That is why I am praying, my lord. Let there
I have given you the opportunity of being heard.
Yes, my lord.
That's why you can produce the documents. And
no, my lord, they may, my lord, take this plea. We shall confine in the four corner of your representation because of certain new documents they have handed over to us. Certain new document. We intend to deal with that. We intend to deal with that. A line may kindly be inserted, my lord.
The authority concerned is the instant petition is disposed of with a direction to the concerned authority, competent authority to dispose of the representation. After giving a reasonable opportunity of being heard to the petitioner, including his further representation, if any. His further representation, if any.
Yes, my lord. Our time may kindly be, my lord, 8 weeks instead of 8 weeks, kindly fix 4 weeks. My lord, all documents are lying with them.
Apply supplementary affidavit. Thereafter, we will have to consider.
Let it be there, 8 weeks and 2 weeks.
We will do that.
Only 2 months.
Within 4 weeks, my lord, we can do that.
It may not be.
4 weeks, it is not possible, I know.
Deeply available. Deeply.
Yes. Next. Rakun?
There is a 12 clock fixed, my lord.
Yes.
Can it be
For the
posted
petitioner.
to any other date? The learned advocate general is arguing the matter. It will take some time. Lordship, kindly fix the matter any date except Thursday, because the learned advocate general has to address the Chief Justice Court on appeal matter. Any day subject to convenient to your lordship at 2 p.m. apart from Thursday.
My lord, I am led by Mr. Pradeep Kumar Tor of the learned senior advocate. My lord, he has also a request, my lord, any day, my lord, this month, as your lordship pleases, my lord, in the second half.
Yes, at 2 p.m. Except Thursday, lordship, subject to convenient of a
I
lordship.
don't have a problem with Thursday, my lord. I am only, my lord, praying that in the second half, any day.
Thursday, Friday, I don't have the determination. Second half, I have the original site.
Kindly the next Wednesday, lordship.
Let me see the diary.
Yes, if the diary permits of your
Summer,
lordship.
yes.
नामটা দিয়ে দে।
দেখো ফেব্রুয়ারি 25 26 কি আছে বলুন না রিট পিটিশন দুটো আছে না একটা আছে 26 তারপরে সপ্তাহ 5 4 5 4 4 5 नहीं अच्छा
Next week,
4th of March.
My lord, 4th of March, my lord, there is a difficulty, my lord. Only, my lord, is it possible in this month? Because lordship knows, my lord, a long arguments.
This month I have only 26. I have already fixed one matter at 2 p.m.
Let it be, my lord, on 26, subject to my learned friends, if your lordship comments to your lordship.
No, land GP is appearing. I have, if I fix 2 p.m., the first matter is there.
Very well, my lord. After that, at 3 p.m. maybe, subject to whatever my lord.
So you are replying in this matter.
Yes.
So let them.
Land GP has to start first.
Advocate General was
Advocate General. Okay, Advocate General has to start first.
Second half,
No, আমার কোনো অসুবিধা নেই। Second half টাই prefer করছি।
Fourth difficult.
Fourth, my lord.
Fifth.
Fourth or fifth, fourth তো মামলাটা থাকবে।
তাড়াতাড়ির জন্য বলছো না অন্য কোনো
তাড়াতাড়ি fix আছে।
Fifth.
Fifth. Very well, my lord. Only
fifth is the Wednesday.
Wednesday, very well. At 2.
Fifth at 2 p.m.
Grateful to you.
Grateful to your lordship.
Let item number 2. Let the matter fixed on fixed of further hearing on 5th of March 2025 at 2 p.m. as a specially fixed matter.
Grateful to you.
Yes.
Lordship, before any submission is 17 or 18?
17.
Oh, 17.
78.
No one is there? Forget it.
In this matter, I am appealing of the petition available. Your lordship has been pleased to direct the respondent to file every opposition. But till this day, he has neither.
I'm not ready with the report, your lordship. The learned advocate on record has fallen ill. Kindly extend the time by 2 weeks. I will file.
Oh, yeah, get to it. It is very
Kindly,
impossible. Man, kindly see.
No, Mrs. Sinha want 2 weeks. What your submission?
1 week maximum.
1 week.
Yes, my lord. Otherwise, very.
Is it possible within 1 week?
On Monday, she is expected to join.
No, she is a.
বাহ আরে টাইম নিয়ে
পার্সোনাল গ্রাউন্ডস আমি কোনো সময় অবজেক্ট করি না
Okay, come on, then 26th.
26
2 weeks.
fine
as a last resort. Otherwise, he is to time date. আমাকে
my
বলতে হবে না।
Okay, okay.
And to soft copy in advance.
Learned counsel.
করে দিই আমি না
Sina appearing on behalf
আপনার
of the
নাম্বারটা দিতে
authority. 6
কে বলেছে
আপনি ফোন করলে পাই।
for extension of time for filing affidavit in opposition.
আচ্ছা
নেন
আপনার
আমার clerk এর
Let
number।
the time for filing affidavit be extended
হয়ে যায় আছি তো।
for 2
Whatever
weeks.
God.
Let the matter appear in the list on 26th of February under the same head.
হয়ে যাবে আচ্ছা
Next,
গেট
Full your lordship নেন আমাকে ডাইরেক্টলি করতে পারেন
কি রাখছেন 20 তো 3 PM আছে 3 PM আছে বন্ধ করুন।
22, I appear for the petitioner, this matter. My lord, was on the last occasion, your lordship was kind enough to direct us to serve copies on the private respondents whose license we have challenged. And that copy was sent, my lord. Unfortunately, what is happening is probably they are probably it's my assumption as of this day that he is avoiding the service. Hence, it has come back as address insufficient. But I would be requesting before moving, since it has fallen from your lordship, that we need to put him under notice. Hence, since during the pendency, his license have been allowed. My lord, I was requesting your lordship for an order on the state respondents so that they may put him under notice that your lordship is taking up the matter. Otherwise, my lord, time and again, we will be trying to serve him and he will avoid service by insufficient address. Address has been provided by the respondents in the website. And the learned senior advocate, my lord, representing the state respondent on the last occasion had handed up to your lordship a list, a result list, which was supposed to be uploaded in the website, but we have not found it on the website. He was kind enough to allow us to take a snap of that on the last occasion. And after going through it, my lord, I have come prepared with the argument that it's blatantly against the policy and the my lord, control order as has been laid down time and again by this honorable court and the statute itself. My lord, I was hoping that my learned senior friend will be. Can it be that order passed by your lordship that the state private respondent be put under notice by the private state respondents?
No, you serve again.
My lord, I shall be serving on the same address. The address will come. My lord, but I am seeing two applications that are there. It is not my application. Some other application.
My application, it is
Who are you?
but I'm seeking to be added party. Since my lord, I was also sit for the exam.
Just take your breath. Application put. What is the application?
It's appearing in the lists, my lord.
Yes. Give me the applications.
What has happened is, my lord, I find from the marks that has been given that in the garb of some few marks being allotted extra to the private respondents, his candidature was allowed. But be that as it may, my lord, I will definitely.
So far I am concerned, I am supposed to get that license because my lord, I obtained 0. I have everything. I have shown, and my lord, I possess much better qualification than others. But my lord, I have obtained only 0.
What is your name?
Right. My name is Shyamol Kumar Roy.
You have scored 0 marks.
Yes, my lord.
In all respect.
In all respect. How can it be? I have better qualification.
তুইও কি চ্যালেঞ্জ করছিস?
হ্যাঁ, আমরাও চ্যালেঞ্জ করছি।
So why you are trying to add as a party in this writ petition?
But I am
Separate-
also
separate
aggrieved.
writ.
But I am also aggrieved. The issue is same. The challenge is against the private respondent number 6. That is also my challenge. But he is not supposed to obtain the work order. So my lord, I am before your lordship. In that writ petition, their claim is also same. Our claim is also same.
No, your claim is not same.
But
I altogether unsuccessful candidate. You have to
possess
plead
better.
You have to plead your case. Altogether, he has pleaded his case. You have to plead it by filing supplementary affidavit, or otherwise you cannot enrich your case in this matter.
But issue is same.
Not
Prayer is
issue
same.
may be
Probably
same.
my learned friend is had filed an application seeking to be added as a party.
I'm just searching the.
Yes, my learned senior friend has come, my lord. I was hence requesting, subject to what my learned senior friend says, that, sir, কপি রিটার্ন করছে ইনসাফিসিয়েন্ট অ্যাড্রেস বলে আপনাদেরই ওয়েবসাইট থেকে নেওয়া অ্যাড্রেস প্রাইভেট রেসপন্ডেন্ট। তো আপনি একটুখানি নোটিশ পাঠান না আমাকে।
How can I help you? I don't know.
I was in
cannot give the address.
no, it has been uploaded by them, their address, my lord. In many matters my learned senior friends appears for the other side, my lord. In
No, it cannot be. You have to serve. If you want any order, you have to serve.
Yes. I have not opened my mouth with regard to the fact of the case, my lord, unless and until it is being served on the private respondents.
Yes. Private respondent name is Rajesh Kundu.
Yes. Stays just
Kundu, yes.
তাহলে লিস্টে এলো কি করে?
Number 6.
Yes.
আজকে ফাইল
Can 1 and can 2 লিস্টে নেই?
আচ্ছা, লিস্টে আছে ফাইল।
ক্যানটা আজকে ফাইল করে আজকে চলে আসবে। When you have filed the can?
But it was supposed to come today only in the list.
Today you have filed?
No. I have filed before. But
In the
it was
list,
supposed
well,
to
can
come
is mentioned, but
in the list can is mentioned. It is
but
supposed
can
to
is
come
not before you.
today only.
Can is not in the list.
No, can number 1 and 2 is appearing in your lordship's
In your
list
lordship.
today. Probably the file may come, my lord.
What I find, my lord, the address of the petitioner and the respondent number 6 almost same.
Yes, that is the whole difficulty we are facing. They are residing a locality just beside us, but they are avoiding service.
I must be knowing his address better than anybody else.
It's way better than us.
And the particulars has been cross-checked by us from the respondent authorities. That
You
is,
serve again.
well, I shall definitely try, my lord, but let there be an additional line in your lordship's order so that my learned senior friends also can put him under notice as clients.
Senior friend is entangled, I don't
No,
know.
not
What I
senior.
have to-
Not senior friend, sir.
I have to find out your address of respondent.
No.
That's not my job.
I was just requesting. I may only request my learned senior friend.
No, in the case of criminal matters, usually we directed the
Yes,
state respondent.
and they
to
are
serve
state
notice.
respondents. That is the
No,
whole.
no. In the civil matter, they cannot be like that.
Well,
Because
they
there are
have
police
given.
authority who can serve.
My lord, what has happened is they have
But
given
he
the
is
license to him.
to serve the appropriate person, and it means that he must find out.
Yes. কি হলো আসেন? করে লিস্টে আজকে ফাইল করলে আগেই ফাইল করেছে তো।
সেটাই
উইদিন 42 আওয়ার্স তো আসবে, 48 আওয়ার্স আসার কথা তো।
24 তারিখ। But can it be taken up on the 24th, subject to your lordships?
He is running.
That is the, we have challenged that.
The MR dealer cannot be found in the locality.
Yes, MR dealer shop is there.
Yes, and we have sent it by speed post with acknowledgement card, and it has returned as insufficient address.
You filed, you again serve and file the affidavit. I shall look at
Yes, my lord, on the 24th, if your lordships kindly pleases.
My lord, can 1
Can
and can
1 and can 2 is running in the list. The can are not placed with the file. Department is directed to place the can along with the file. Next paragraph. Learned counsel for the petitioner submits that he could not serve upon the private respondent. The petitioner is directed to serve again upon the private respondent and file an affidavit of service on the returnable date. Let the matter appear in the list on 25th.
Grateful, my lord.
Under the same heading.
Service by registered post with AD. Speed post. That is the lordship directs.
আমরা করেছি স্যার, ওটাই তো বলছি।
My lord, along
Insufficient
with,
address বলে ফিরে
matter to be listed along with can 1 and can 2.
Yes, can 1 can 2.
কপি দিয়ে একটু বাবা, কপি দিছে।
I don't know what can 1 and can 2.
এই তো but আপনাকে
Just let me finish the matter.
হ্যাঁ স্টেট কে করা addition of party.
My lord,
I have not been served.
You have not received any.
I have not.
I have also not produced anything. Have you not served their copy of the parties?
Service is not complete since pilot it has not been allowed. But I will serve in due course.
Okay, very well.
my lord, let it appear on the 25th. Which
For your lordship rises the very next matter.
I am not rising, just. Okay.
My
On
lord, just
25th, I
just
will
for
have
information, my lord, the can 1 and 2 was filed on 11/2/2025.
11th,
to 2025. My lord, the
11/2. Yesterday.
yes.
Then it will take 48 hours to reach this court.
let us come back on the 25th.
Yes.
Grateful.
Item number 20.
Call next matter.
My lord, item number 23, I was praying for a not today, my lord. My lord, this.
You are appearing in the matter.
I'm applying for respondent number 7.
Yes.
My lord, there was a direction upon me to serve upon. My lord, Tuesday. And my lord,
Tuesday. You are
My lord, I am appearing for one of the private respondents.
private respondent.
Kindly let it be
Who-
after 9.
Who is appearing for the answering respondents? You are appearing. Okay. An accommodation is sought for on behalf of the petitioner. Let the matter be adjourned to release the matter on 26th.
Well, let there be a fixed matter because every day, my lord, some way or the other, we are
Very
in difficulty. Let it be fixed any day so that we can,
Then it come on 24th, Monday.
as per your lordship.
Monday.
my lord, I'm grateful
Very.
for that.
Call the list.
My lord will kindly direct your lordship to continue for the air conditioning, my lord.
What is the date?
No question, if your lordship directs, my lord, they will.
But there are fixed date.
That date is cannot be my. Oh, no, not over, but will be over. But now the date has come back. It should have been
15th February is the date.
15 March or 15 February. I do not.
15th February. Nowadays, 15th February is the date.
So we'll have to.
Yes.
Today
very hot.
Very hot, my lord.
Very hot.
It's a bit suffocating inside court.
In the other courtrooms where the individual ACs are there, I was in the court number 13 in the morning. It was quite pleasant.
Now, if we open the doors, that would be better.
That may be better, my lord, but
otherwise it is suffocating.
Suffocation. But if you are
very well, I'm just right. Yes.
My lord.
Item number 1, na?
Yes.
I'm led by Mr. Colin.
I'm appearing for University Grants Commission, led by Mr. Anil Kumar.
My lord, I'm led by Mr.
Millard, this is a case, Millard, where the order of a pay revision.
Yes.
Millard, that was implemented by the state, Millard, according to its whims and caprice. Why I tell your lordship this, Millard? Because the pay has been revised. And, Millard, there was the government of India, Millard.
7th Pay Commission
Yes.
date is 1st January 2016.
Right.
And the state has revised on 1st January 2020.
Right.
This is the issue.
Now, Millard, in between 16 to 20, the gap, Millard, we were entitled, Millard, to reap the benefit of the pay scale as that was showered upon the other employees, teaching of staff, Millard, of Millard, of the other government, those who have followed Millard UGC. Till 2016, Millard, the sharing of funds that was, Millard, taken care of by central government and state government so far as the revision is concerned. Till 2016, Millard, this condition, Millard, continued. Suddenly, Millard, 2020, when the state has decided to, Millard, revise the pay, Millard, the state did not discriminate with regard to the quantum of the scale ultimately we receive at the end of the day, because there was no disparity, Millard, that was given, maintained. But from 2016 to 2020, till such, Millard, decision was taken, we lost this, Millard, a gross financial benefit. Now, state did not assign any reason as to why such discriminations, Millard, were meted out by the college teachers and for what reason. Because if the pay commission does not take into an account of such revision of pay so far as we are concerned, and even then the state has implemented and the central has shared the amount in terms of the UGC, there is possibly no reason for the state.
Now, whether it is obligatory upon the state that they
Question is, Millard, this is, Millard, the stand taken by the state in 2020. The state, Millard, has taken a decision. It is a conscious choice of the state that I will give it. If there is no reason, Millard, then also the state, it is a presumption, the state ought not to have taken such step. State has implemented the date on and from 1/1/20, suppose. It continued up to 2016. So between 2016 and 2020, why the why these 4 years we were deprived of the amount That has to be answered. Because continuation I'm claiming, my lord, because I have suffered a loss.
Yes.
Now, what is my, kindly sees the representation. The regulation, page 91, Millard, sorry. That is, Millard, it delineates a definite contour of our grievances, Millard. May I read for my lord? We the undersigned the teachers of college. 91, Millard.
91. Page 91.
My lord.
Yes.
We the undersigned the teachers of colleges and universities in West Bengal, we are writing this letter in order to ventilate our grievances against GO number such and such issued by the concerned authority of the government of West Bengal, whereby and whereunder the pay scales of the university, college teachers and librarian are revised in terms of GO number 25th September 2099 or the ROPA 19. The Ministry of Human Resource Development issued a recommendation for the pay revision of the college and universities VDA dated 2nd November 2017 all over the country. The UGC VDA such and such dated 31st January 2018 formulated a scheme for revision of pay of teachers for implementation by state governments following the revision of pay scales of the central government employees on the recommendation of the 7th Central Pay Commission. That is, your lordship has recorded on the last occasion. We being the teachers of colleges and university come within the purview of the said scheme. To the utter surprise of the undersigned, the government of West Bengal issued the GO number 30th December 2019, whereby and whereunder the pay scales of the University of College teachers and librarians are revised in terms of the GO number 25th September 2019 or the ROPA 19, which is utterly illegal, as the university and college teachers are not included in terms of the reference of the pay commission, and we are enjoying the pay scale as per the scheme of the UGC following the pay scales of central government employees. Millard, this is the submission which I have made, Millard, without taking your lordship, Millard, that this is, we were not included in the terms of reference. But the state government has scrupulously followed, Millard, the UGC revisions and, Millard, the central government which I have stated. Now, Millard, it is needless to mention that the college university teachers are not included in the terms of reference of the pay commission. Such fact was also reiterated in the letter number such and such dated 21st July 2017, whereby the concerned authority of the higher education department stated that since the college and university teachers are not included in terms of the pay commission and they are covered under the UGC pay scales, therefore, the proposal for granting relief to the retired college university teachers were declined, holding they are not entitled to same. Such fact was communicated as per the observation of the finance department. Thus, the issuance of the said GO dated 30th December 2019, bringing the university and college teachers within the purview of ROPA 19 is not only illegal but contrary to the stand of the government. Such illegal action not only arbitrary, whimsical, causing violations of the fundamental rights such and such. Under such and such, we humbly beseech you to withdraw the cancel such and such and revise pay scale under in terms of the recommendation of 2/11/27 and the subsequent scheme of the UGC dated 31/8/2018. We sincerely hope for a positive response within a period of 7 days, failing which we shall be constrained. So, Millard, this is our stand. Now, what the government has said, Millard, kindly take pain, Millard, to turn opposition filed by the state, one Mr. Shiladitya Chakraborty, Millard, 1 to 4. The first stand, Millard, page 2 of the AO.
Yes.
They first taken the first point that has been taken by the state, Millard, that the state-aided university and the state government-aided colleges, they were established and financed absolutely by the state government out of its own fund.
Paragraph
2. Paragraph 4, subclause 1, Roman 1, page 2, paragraph 4 of the affidavit filed by the state.
Yes.
Yes. I'm sorry, minute, only 1 minute, 1 minute time, minute. 10th March. My lord, the first of all, my lord, that they said, my lord, that the state government is the only authority which financed, my lord, the state-aided university.
Absolutely by the state government.
Absolutely.
Own
So,
fund.
own fund. Then they said all salaries, allowances have been paid by them. Neither state government nor the central government or UGC have paid any kind of salaries. So prescriptions of the UGC or the central government, it does not have any binding effect on the state. Then the parity of scale, my lord, on the conspectus of such fact is also not maintainable. I said that this should be there from 2016 to 2019, but this was not given to us. Now, my lord, they referred that 2nd November 2017 has not been accepted or adopted by the state. The prerogative is, my lord, lying with the state government, whether they will accept or not. They said, my lord, further that 31st January 2018, this UGC memo, my lord, are applicable to the state funded and or this is our fallacious premise. This is not applicable according to them.
State fund university college university fund. Wholly devoid of merit.
Right. Now, my lord, the next important legal point in the affidavit is this, that in terms of section 12D of the UGC Act, only enables the UGC to advise and recommend. Therefore, the legislative intent is clear from the statute that regulation by UGC under the UGC Act cannot be mandatory in nature. They further said, my lord, that section 14 provides for consequence of failure of the university to comply with the recommendation of the UGC. It is provided thereunder that UGC may withhold from the university the grants proposed to be made out of its fund. Then that is why the UGC pay scales or pay, that is our claim, my lord, is also frivolous. That is baseless and frivolous. Then, my lord, they said that the memo, my lord, which I have referred, my lord, that the such and such, that the memo dated 31st January 2018 were to be made applicable to the state-aided and state-funded university colleges if and when the state government adopts or implements the concerned scheme. In the present case, the respondent authorities have not adopted the UGC memo dated such and such. Therefore, there is no question whatsoever implementation of the scheme of the University Grants Commission dated such and such. Particularly in view of the fact that the scheme mentioned above is specially meant for the universities and colleges, institution administered, funded, and maintained by the central government. It was neither binding nor enforceable. Then this case said, my lord, this scheme shall be applicable to other equivalent academic staff in the central university. So first, my lord, they said it is not binding in nature. Second, said it is a centrally funded, then it is applicable. Third, my lord, the entire state university and colleges that was funded, established by us. So we are not bound by any recommendations or memo, my lord, by the UGC, because the UGC, my lord, the recommendation, that is a advisory in nature, I am not bound to comply.
And they have not adopted the.
No, not adopted.
Not adopted.
Then, my lord, while, my lord, we have repeatedly said that 2nd November 2017 memo, that is also, my lord, we relied on. To which, my lord, they said that by way of the said scheme, revision of pay of teachers and equivalent cadets, including Vice Chancellor of University and colleges, was notified. As aforesaid clause 16 of the said scheme specifically provided that the implementation of the same is subject to adoption and implementation of the said scheme by the state government. It is only on such adoption and implementation of the said scheme, along with UGC regulation and financial assistance, was to be provided by the central government in the manner as provided therein. Moreover, as per the said scheme, the payment of central assistant for implementing the scheme is dependent upon the implementation of the UGC regulation. In this regard, specific reference may be made to clause 16.1, 16.4, such and such. The 2018 regulations were the outcome of the scheme dated 2/11/2027. The implementation and adaptability is interlinked with the adoption of the scheme. Now, they said that next paragraph 16, page 8.
Yes.
The applicability of scheme, Millard, when clause 16 was this, Millard, taken, it is notified, it is stated that the adoption and implementation of the said scheme was left upon the discretion and policy decision of the state government, subject to fulfillment of certain terms and conditions which are reproduced hereunder. The scheme shall be applicable to teachers and other equivalent academic staff in all central universities and colleges thereunder and institutions deemed to be universities whose maintenance and expenditure is made by the UGC. The implementation of the revised scales shall be subject to the acceptance of all the conditions mentioned in the letter, as well as regulations to be framed by the UGC and amendments thereof in this behalf. Universities implementing the scheme shall be advised by UGC to amend their relevant statutes and ordinances in line with the UGC regulation within 3 months from the date of issues of the letter. The scheme does not extend to the cadres of registrar, finance officer, and controller of examination, for which a separate scheme is being issued separately. This scheme does not accompany coaches, tutors, and demonstrators. Pay of the categories of employees shall be fixed in the appropriate relative level to their existing pay in each university institution, corresponding to such fixation in respect of the central government employees as approved by the central government on the basis of the recommendation of the 7th Central Pay Commission. This scheme may be extended to universities, colleges, and higher education institutions coming under the purview of state legislature, provided
State government wishes to adopt.
State government wishes to adopt and implement the scheme subject to the following terms and conditions. Then, Millard, 50% to be additional, that will be the state government.
Yes.
50%, Millard, the state government, this proposal was there. So, today, Millard, quoting 16, Millard, they said this is not binding. Now, our response in the reply.
Your reply.
Paragraph 6.
Against the epitome 1 to 4.
Reply. Reply, Millard. Professor Suratna Ganguly, Millard.
Paragraph 6. Yes.
Millard, kindly comes to paragraph 6, Millard, the 1, 2, top 2, 3, 4, 5, 6, 7, Millard. I respectfully submit that although the pay and allowances of the employees of the state-aided university and colleges are paid by the state, however, they receive grant or funding from the University Grants Commission and from the Government of India under different schemes such as Rashtriya Uchatar Shiksha Abhiyan for infrastructural development or for conducting any project. I further submit that the West Bengal Services Revision page 19 issued under such and such, dated 25th September, was made pursuant to the recommendation of the Pay Commission, which was made after taking into consideration of the pay scales of the state government employees and the petitioners being in receipt of UGC Commission scale of pay were outside the purview of the same. Before such pay revision was implemented, the respondent number 1, by way of a letter dated 21st July 2017, stated that since the college university teachers are not included in the terms of the pay commission and they are covered under the UGC pay scales, the proposal for granting interim relief to the retired college university teacher was declined, holding they are not entitled to the same. Such communication was made pursuant to an observation made by the respondent number 2, as mentioned in the said communication. As such, it cannot be stated that the petitioners cannot claim to be guided by the UGC regulation. Then I reiterate Then, my lord, I said, I specifically deny that the central government scheme issued by the ministry dated 2nd 11/2017 has not been accepted by the state, or that the scheme forwarded by the UGC dated 31st January 2018 are not applicable to the state university colleges, or the writ petition is devoid of merit or any regulation, or it is not mandatory in nature, or that the claim of the petitioner such and such. I respectfully submit that the pay of the teachers, I am skipping over 2 lines, minute, of the teachers of the state-aided university and colleges were guided by the respondent state authorities concerned, dated 30th December 2019. In the said order, there is no whisper that the recommendation of the VGC with regard to the revision of pay has been accepted, or the pay is being revised in the light of the recommendation of the UGC. I further submit that the recommendation of the UGC in the light of the 5th Pay Central Commission and 6th Central Pay Commission were accepted by the state government in unequivocal manner, and accordingly the pay of the teachers of the state-aided universities and colleges were revised, and the teachers were paid their dues. Such actions give rise to legitimate expectation to the petitioners that the recommendation of the UGC such and such 31st January 2018 following the 7th Central Pay Commission will be accepted and implemented by the state authorities. The GO number such and such 30th December 2019, although does not refer to the UGC's recommendation dated 31st January 2018. However, most surprisingly, the UGC's recommended pay scale and the state government's recommended pay scale are identical, which I have said at the outset. Such action clearly shows that the respondent state authorities have accepted the recommendation of the UGC dated such and such, following ministry's recommendation dated 2/11/2017. However, such fact has been suppressed by the respondent authorities concerned in order to avoid to perform all duties and obligations in terms of the recommendation bearing 31st January 2018. Such action was committed in a fraudulent manner to deprive the petitioner from getting their legitimate dues. Now, my lord, kindly comes to paragraph page 7.
Yes.
Millard, kindly it comes, Millard, to the paraphrase. The line starts from, I respectfully submit that the revision of pay cannot be made out of thin air, and the same is done pursuant to recommendation of any commission constituted for such purpose. When the respondent authority is concerned, my lord has got it.
Yes.
Constituted the pay commission under reference number 20 such and such dated 27/11/2015, it was categorically mentioned that the same is being done to examine the present structure of pay and condition of service to the specific categories of employees after taking into account the prevailing pay structure under the central government, public sector undertakings, other state government, etc., and to furnish recommendation for changes which may be desirable and feasible, and in the same inter alia, the members of service to whom the university grant commission scales of pay apply were specifically excluded. As such, bringing any parity with regard to implementation of the revision of pay to the teachers of the state universities and colleges with that of the state government employees will only bring inequality. I further submit that the memo dated 31st January 2018 categorically stated that any deviation from the recommendation has to be approved by the state government, by the government of India, and the state government has no unilateral discretion with regard to the scale of pay or date of implementation. Admittedly, GO dated 30th December 2019, following the recommendation dated 31st January 2018, and the acceptance of such recommendation has been suppressed by the respondent authorities concerned only to avoid their obligation of implementation of the said recommendation in its entirety without any exception. Under the said memo dated 31st January 2018, the respondent authorities concerned has no discretion to implement such recommendation in a selective manner, and the same has to be implemented in its entirety. I reiterate the submission made in a different paragraphs of the writ petition. I crave leave. Then Millard kindly comes to 9. Millard, this is also very important. It starts from, I respectfully submit that admittedly the revision of pay of the petitioner as per GO dated 30th December 2019 was made similar to the recommendation made memo dated 31st January 2018. As such, there is no iota of doubt that the respondent authorities concerned has accepted the recommendation. However, the same was suppressed so as to enable them to avoid discharging all their obligations pursuant to such acceptance. Once the recommendation is accepted, the petitioners have the absolute right to get the benefit of the same in its entirety, and the same cannot be curtailed in any manner. In order to avoid such responsibility, the respondent authorities concerned have not provided any response to the petitioner under the RTI Information Act. In the said affidavit also, no file note of the said GO dated 30th December 2019 has been provided to show the basis of such revision of pay. The respondent authorities concerned also did not produce any document to suggest that they have communicated to the Government of India or UGC their alleged concern to the scheme dated 31st January 2018 or any other communication in this regard. As such, it is evident that the respondent concerned are withholding information and invite adverse presumption of the Honorable Court. Now, my lord, I will sum up. First of all, my lord, till 2016, there was no complaint. Before that, my lord, the history of Fifth Pay Commission, Central Pay Commission. My lord knows the Pay Commission is an expert body. Government is not bound to accept the Pay Commission's recommendation.
State government.
The state government, or in case of central government also, my lord, the same principle applies. But the moment, my lord, they accept it, that cannot be accepted in a selective manner or in a fragmented manner. That has to be accepted in its entirety. Now, my lord, the functions of the expert body, my lord, they have taken note of, my lord, all the relevant data, and it is a summation of, my lord, synthesis of this data. Because these data, my lord, I have said in my affidavit and tried to elucidate that such synthesis of, my lord, the all different data, my lord, ultimately enable them to reach to a conclusion and to make recommendation. They were, my lord, really expert. They knew their fields, and, my lord, while taking into this consideration why we, the teachers of the university and colleges, were excluded, the government, my lord, in unison voice, my lord, possibly, my lord, there was a discussion, or the Pay Commission's experts, my lord, found that these kind teachers have already been protected
By
UGC, and state government has adopted a certain procedure and a shared responsibility, center state, my lord, in a few federal structure, my lord, that has been, my lord, implemented. So no double benefit, my lord, cannot be conferred upon them during that period. So it is a conscious silence and a conscious choice on the part of the state, my lord, not included, and rather the Pay Commission. Pay Commission. So that is why there was possibly no grievance so far as we are concerned. Now, what is acceptance? My lord, your lordship knows there is an adoption or, my lord, incorporation by reference. Now, question is that this is not a case that till 2016, the recommendations, implementation of the recommendations made by the government, where, my lord, there was no space for any grievance for us, my lord, whether that was a mistake on the part of the government or there was a misrepresentation or fraud committed by the teachers of the all states and university, by which government was induced to believe something. Because I did not decide my pay structure. It is the expert body. So there was, my lord, in a participatory democratic process, the Pay Commission, government, my lord, there was meeting of two minds. And ultimately government had decided, and the government had consciously, my lord, excluded us from that zone of consideration, as we are already covered. So there is no morsel of proof or any evidence by the state to show, and that is also not the case. I went further, my lord, because so such exclusion was conscious and reasonable so far as we are concerned, because we are already covered. Now, 30th December, 25th September 2019, we are also not included, rightly not included, because on the date when the Pay Commission 19, ROPA 19, my lord, came, the UGC, my lord, the Pay Commission, my lord, thought that this was there, and government, my lord, ultimately, when there was, the government did not make any gap between the two different pay scales. Government has given the same thing. I have said on 2020, in view of 1919 recommendation, which we are not included. Government will not maintain the parity. This, my lord, I specifically consciously, my lord, use the word this parity between the centrally funded university according to the government and the state funded university, my lord. There was no disparity from 2020. It is also not by any accident. It is also, my lord, a conscious choice of the government. Government thought fit and proper. Otherwise, if there is a discrimination, then, my lord, this disparity would demolish the previous parity and stability, my lord, that was maintained till 2016. So, the financial loss, my lord, that we, my lord, had to meet. The question is, my lord, did we alter the position? My respectful submission, yes, because it was a promise on the part of the employer. My lord, state is a role model employer. Central government is a role model employer. So every action of the state, my lord, it has to be. Sorry, my lord, I apologize. So, my lord, the choice of the government, my lord, the government cannot take any decision, my lord, which is contrary to, my lord, Article 14. My lord, your lordship knows I will not burden your lordships with any judgment. My lord, the basic premise of the Constitution says equals should be treated equally. So, my lord, on this premise, when the pay was given to me, and, my lord, it is in parity with the, my lord, this, and there was a shared responsibility in a federal structure, my lord, I put this question to myself: am I, my lord, whether I am correct in making such submission before the highest court of law, constitutional court, that such action on the government, which is a conscious choice on the government, which become a practice, whether, my lord, it attracts a doctrine of promissory estoppel or legitimate expectation. I altered my position. It is nobody's case in the instant proceeding that every payment that was made till 2016 was made by mistake or actuated by any malice or fraud. There was a shared responsibility in a federal structure. 2020, my lord, is a repetition of that journey, because 2099, my lord, the moment the government is, my lord, forwarded or favored with the pay commission recommendation, when the government finds that we were excluded from the zone of consideration, government, my lord, again, my lord, reiterated the stand, yes, this should be implemented. So, my lord, when we go to the river, my lord, we also, my lord, we also dream of making a bridge. So, my lord, the question is, it is a bridge, my lord, why this vacuum will be allowed to exist? And if it is allowed to exist, then why till 2016 and my lord, on and from 2020, why, my lord, this parity was, my lord, maintained? So, my lord, it is a practice.
2016, there are parity.
Right. Because 5th and 6th Pay Commission.
Now, state says they are not bound
Yes. Now, question is,
they are going to.
Why? Now, question is,
now in the year 2020, they came again.
They came again and maintained the parity.
Maintain the parity.
Parity.
So why
now,
not for the
why not? Because the common state is, the common factor is, if your lordship, the recommendation, paragraph 16 and 17, page 37 of my writ petition. My lord has got it.
Yes.
The scheme shall be applicable to teachers and other equivalent academic staff in all central university and colleges thereunder, and the institutions deemed to be universities maintaining expenditure made by the UGC. The implementation of the revised scales shall be subject to the acceptance of all the conditions mentioned in this letter, as well as regulation framed by the UGC and amendments thereof in this behalf. Universities implementing this scheme shall be advised by UGC to amend the relevant statutes and ordinances in line with the university regulations within 3 months from the date. Then, my lord, clause 4. My lord, this clause, my lord, are required. These clauses are required to be placed. This scheme may be extended to universities, colleges, and higher education institutions coming under the purview of the state legislatures.
Provided.
state government wish to adopt and implement the scheme subject to the following terms and conditions. Financial assistance from the central government to state governments opting.
Part of their
Yeah, also. Now, my lord. Yes. Now, condition is first is, my lord, the state government opting for revision of pay shall meet the remaining 50% of the additional expenditure from its own source. The proposal for reimbursement on account of pay revision in the state-funded university, colleges, or higher education institution shall be submitted in the prescribed format by the state governments. State bills preferred by the state governments for reimbursement during 2017-18, 2018-19 would be made to the extent of 50% additional financial impact during these 2 years. There would be no central assistance thereafter. Financial assistance referred to in clause A above shall be provided for a period 1/1/16 to 31st. This is the period which we are claiming. The entire liability on account of revision of pay scale, etc., the university and colleges shall be taken over by the state government, opting for revision of pay scales with effect from 1/4/1919. Financial assistance from the central government shall be restricted to revision of pay scales in respect of only those posts which were in existence had been filled up as on 1/1/2016. We are covered by this, Miller. The state government taking into consideration other local conditions may also decide their discretion to introduce any higher than those mentioned in the scheme and shall give effect to the revised band scales pay from 1/1/16. However, in such cases, details of modifications proposed shall be furnished to the central government and central assistance shall be restricted to the pay as approved by the central government and not to any higher pay fixed by the state governments. Payment of central assistance for implementing the scheme is also subject to the condition that the entire scheme of revision of pay scales, together with all conditions to be laid down by the UGC by way of regulation and other guidelines, shall be implemented by state governments and university and colleges coming under their jurisdiction as a composite scheme without any modification, except in regard to the date of implementation and pay scales mentioned herein above. Miller, this starts from Miller, page 32, possibly. This is Miller, 2nd November 2017. Which Miller? My lord, got it? 32?
Yes.
It is said, Miller, scheme of revision of pay of teachers, equivalent cadets in university and colleges, and the following the revision of pay scales of the central government employees on the recommendation of the Central 7th Special Commission.
Yes.
Now, the two things, Millard, are very categorical. First, Millard, the proposal for 1616C, the on account of pay revision in state-funded universities, colleges, and other education institutions shall be submitted in the prescribed format by the state. The state bills preferred by the state governments for reimbursement during 2017-18 would be made 50%. But admittedly, Millard, this was not given to us. Financial assistance referred to shall be provided for the period of 1/1/16 to 31st, 2019. Now, Millard, this revision, this UGC recommendation, if your lordship looks at page 32, your lordship would be pleased to find that 32 is not coming out of Millard nothing. It says, Millard, scheme of revision of pay of teachers and equivalent cadres in university and colleges in the revision of pay scales of central government employees on the recommendation of the 7th Central Pay Commission. UGC, Millard, by dint of such recommendation, Millard, has included us, Millard,
This is the
subject
letter to the UGC.
Right. The government of India said, that is, Millard, it was issued by the Millard government of India. UGC, Millard, adopted this. Centrally funded university adopted this. Millard, the pay commission, since did not include the college teachers, and the forwarding letter, Millard, page 30, 30th January 2018. If your lordship looks at it, Millard, your lordship will be pleased to find scheme of revision of pay of teachers and equivalent cadres in university and colleges following the revision. This was P.K. Thakur, Secretary, Ministry of University Grant Commission, to the Vice Chancellor of all Central University and UGC maintained deemed to be university as per 8 lists attached. Now, my lord.
Yes. This is the letter from the UGC.
UGC to my lord.
All central universities.
Yes. And my lord.
Forwarding this memo, that is 2nd November memo.
Yes. Now, my lord. This is the forwarding letter, but the contention is subject to confirmation.
Yes.
So, my lord, had it been a case that our names were not have been included in the pay commission, I cannot, my lord, ask for double benefit. The 5th pay commission, the state government affidavit, my lord, I again repeat at the cost of tiring repetition, does not indicate the history of the previous payment. It does not indicate why the state government has, my lord, included us in 2019 after the 6th pay commission, that is my lord, 25th September 2019, why we are included. And my lord, before that, only gap is, my lord, 16 to 19. So, my lord, common set is this, that the pay commission recommendations do not include our names. Pay commission recommendations, why it did not include our names? There was a conscious choice of the pay commission as well as the government that our pay protection was given by following the UGC recommendation, and there was a shared responsibility in the federal structure. The omission in the affidavit by not incorporating the previous history,
yes,
that is 5th and 6th pay commission, is deliberate, and my lord, this is with a view to suppress the entire thing.
Yes.
My lord, since your lordship, my lord, had a, my lord, roaring practice, my lord, in the civil court once upon a time when your lordship is in the BA bar, my lord, your lordship was confronted with certain cases which requires, my lord, the RS record, alluvian land, my lord, Shikosti, that is the land, my lord. There were a period, my lord, that in that type of matters, my lord, we normally refer, my lord, to the definition of what is alluvian, diluvian. At the time of RS Porcha, in terms of Asset Acquisition Act, what was the position of the land? So these histories will not be narrate in the land matters, and what is the Land Reforms Act when this particular act was, my lord, given complete go by, and it was included in section 12 of the Panchayat Act, alluvian, diluvian, and my lord, how this 7th April 1965, after Land Reforms Amendment, these histories are required to be presented before the court of law while we decide that whether a particular land belongs to the state or a private owners. So in this case, my lord, why I said the history of, my lord, the entire journey, the history of the entire, my lord, financial payment, my lord, why this is a stopgap? Because first of all, if the state had come up with a clean hands by disclosing this fact, 5th and 6th Central Pay Commission, what was the point of reference? Whether the teachers were included, even then they were given a double benefit. What was the history? This cannot come, my lord, out of nothing. There must be a logical end of any curial combat,
yes,
and there must be a logical path while we analyze, my lord, certain rights while we press before your lordship for adjudication. The state cannot suddenly come up and say we are not bound at that. State has obeyed this. State has maintained parity. State has again maintained the same parity. But state is not intending to invoke clause 16 of clause 16 subclause 4 within bracket C of that particular 1/1/16 to March 2019. Because the subject to adoption, the state did not do so. Question is whether state can do it. If the answer is yes, then state has to show that what the recommendations and why because I said, my lord, at the cost of tiring repetition, in September 19, when the 6th Pay Commission, my lord, came, ROPA 19, our exclusion from the recommendation list, that is correct. If that is correct, why it was correct? The moment state realized it, state said, if we do not reform, if we could not enhance such pay, if we do not maintain the parity, then really the college universities teacher will meet a real discrimination. But question is, that is also not forthcoming. Why the state has taken a decision?
They are saying this is the policy of the state,
Question is that whether policy can be without question before the court.
arbitrary or not, that is the.
My question is, what is the definition of arbitrariness? I put this question to myself. Arbitrariness possibly, my lord, has not been defined in any of the judgment. Sometimes we rely on the wisdom and perception of a judge, my lord, in the context of Article 14. But question is, when state has maintained continuously a particular stand and sudden aberration or deviation from such stand, my lord, if it creates economic inequality or deprivation of our financial right. Because, my lord, payment, salary, pay allowances, it indicates, my lord, the dignity of a post.
Yes.
So, my lord, when we talk about, my lord, the dearness allowance of the employees, we are not claiming charity from the government. It is our right, which is, my lord, being adjudicated before the Honorable Supreme Court. So, my lord, state being a role model employer, whether I am entitled to raise a question that when our inclusion was in a justified manner, the exclusion must be, my lord, has to be justified in the anvil of Article 14. Now, the element of arbitrariness, my lord, in this proceeding is, my lord, apparent from the state's silence. Had it been a case like a deed, my lord, we knew, my lord, possibly, my lord, subject to correction. I am not very much aware of any civil law, neither constitution, no law. But still, my lord, when we talk about recital in Bengali, we say, সম্পত্তি হস্তান্তরের বিবর্তন. That is, my lord, the history of transfer of the property.
Yes.
Now, my lord, in this case, what is the history of such, my lord, payment? What is the history of, my lord, the point of reference? If the state does not come up with this, my lord, the state is also depriving a citizen as well as a constitutional court to lend meaningful assistance, my lord, to adjudicate a proper lease between the parties. Because I understand, my lord, with humility, subject to what my lord said, any constitutional matter, when it comes to a court, my lord, we invite the highest court of the state to make a gap between, to make a bridge, my lord, between the human rights and human sufferings. State is also, my lord, equally important litigant. State is also not, my lord, we should not make any such unreasonable prayer, my lord, which would ultimately cause any prejudices to the state. But in the instant case, my lord, a bunch of, my lord, professors, teachers who had rendered their service, who had given their, my lord, suddenly, my lord, they were met with, my lord, deprivation. And, my lord, question is, if this is not arbitrariness, because why this? Because this period, if you consider 1/1/16 to March 2019, we were certainly, my lord, we were the victims of, my lord, discrimination. Because these 3 years, my lord, we did not, my lord, get our actual dues. Whether, my lord, such financial deprivation, because your lordship was at the outset was asking me, what is the obligation? I know when there is a duty, automatically duty brings obligation.
Yes.
But duty to maintain a consistent stand in the context of a law, my lord, is also, my lord, creates an obligation. When you have complied with 5th and 6th pay commission, that means you felt a consistent duty. It is not from the record that such consistency made by the state in line with the pay commission exclusion or recommendation, whatever it may be, we paid this amount, we shared this responsibility. That is not an accident. It is absolutely a conscious design within the constitutional parameters. And today, when 2019 you maintain this stand, you bring back the same resonance which you maintained till 2016. But why this gap? But I will give, you know, 2 decisions in the next day and I will conclude.
Okay.
এই কবে করবে গো? আমার আর 10-15 মিনিট লাগবে। না না গৌরাঙ্গ খান Milord, subject to correction, Milord. 7th March possible, Milord. Or Milord, or 14. হবে না? 14 বন্ধ না? ও আচ্ছা আচ্ছা দাঁড়া 21 তারিখ থাকবো না। 21 হ্যাঁ মার্চ দেরি হয়ে যাবে। ফেব্রুয়ারিতে করি? হ্যাঁ ফেব্রুয়ারি হবে না? হ্যাঁ 12-3 হ্যাঁ করে দিন। দাঁড়ান 1 সেকেন্ড একটু দাঁড়ান 2 মিনিট স্যার। সরি ইয়েস ইয়েস ও 12ই মার্চ না দাঁড়ান 1 মিনিট ভাই। হ্যাঁ 12ই মার্চ দুটোর সময়।
12th March.
Deeply obliged. I'm sorry, Milord.
No. Argument on behalf of the petitioners heard in court. Let the matter fixed on 12th of March at 2 p.m. Huh? It is the second matter. Second matter order করা আছে। Yes, call the matter. এক নম্বরটা দেখো।
And item number 4 is also heard in part. My learned friend is appearing.
But it may not be taken up today because it is at 3:30. If your lordship.
Yes. Item number
4, the next 4. But,
this matter, that is part and
yes,
matter.
yes.
Abhijit Kaur Modhok.
Yes, madam. If you also take it up on my London senior friend says he may be in difficulties on Monday. If it is also on next Wednesday, they are top. At 2.
19th.
19th. At 2 p.m. If it is.
Let me find out whether it is possible. Already 2 matter fixed.
Then 20th, 18th, any day subject to your lordship.
20th is Thursday. Second half I have original side details.
Original side matter, yes. But on Tuesday, if it is on, because my landed, I don't have any problem on Monday. If my landed senior friend.
17th, I have some difficulty.
26 তারিখ দেখো তো 26 26th
at 2 p.m.
2 p.m.
But I come at top mallet if your lordship.
I have already fixed a matter on the 26th. কোনটা করেছি দেখো 26th এ কোনটা রেখেছি কি আছে রিট আছে নাম্বারটা বলুন
Fourth March.
আজকেই রাখলাম It will be second matter. I have already fixed the matter. Today I have fixed the matter.
4th March, my lord, if possible. 4th
March.
My lord.
দেখো তো 4th March হবে হ্যাঁ 4th March 2 p.m. top
March. Great.
Let the matter fixed. Let the matter item number 4. Let the matter fixed at 2 p.m. On 4th March at 2 p.m. on top.
March. Grateful. And also grateful to my landers. Yeah.
Yes, item number 1.
Well.
Lord. 20.
For item 20 is fixed at 3 p.m. Possibly this matter will continue.
Yes.
So other matter release, my lord.
Okay, not that, actually.
Yes.
My lord, the other day, my lord, perhaps, my lord, the page 134, this paragraph was troubling my lord. Well, that particular observation, my lord, in the
Last
judgment.
part, one paragraph.
My lord, in this case, there is no complaint regarding service rendered.
Yes, yes.
My lord will kindly take the paragraph before that, my lord, the second top paragraph, my lord. For the appellant to insist that the agreement would permanently stand terminated on death of the partner is an extreme step. It would be reasonable if for the time being it was terminated. Thereafter, the partners of the reconstruct firm and the appellant should be given an opportunity of entering into a fresh agreement. So, my lord, this was the observation. In this backdrop, my lord, this option was given, according to me, my lord, to enable the petitioner before my lord, to comply with the policy circular, my lord. This time of 1 year was given, my lord. Then, my lord will kindly seize the page 135, my lord, the last sentence, my lord, in the the last, may I still read from this? In those circumstances, my lord, I have read it before also.
Yes.
In those circumstances, this court upholds the decision of the appellant to terminate the agreement. By virtue of the status quo order in the writ petition, the respondent firm continues to be a dealer of the appellant. It shall continue to do so on a permanent temporary basis. The appellant is to take a decision as to whether it will renew the dealership with the reconstituted first respondent on a permanent basis, on the basis of the above observation and after taking all relevant factors into consideration. Now, my lord, I put emphasis on the word after taking all relevant factors into consideration. My lord, this is, my lord, this was, my lord, this relates to, my lord, the policy circular also and the provisions of the agreement, the dealership agreement. My lord, in this regard, my lord recollects the paragraph 42 of the dealership agreement says that the dealer has to comply with all the guidelines, rules, and circulars in the matter of running of the distributorship. So, my lord, the compliance of the covenants of the agreement is also, my lord, one of the important consideration. And, my lord, the following the my lord, dealer to follow the rules framed by the corporation is also
Reconstitution policy.
my lord, reconstruction is also an important consideration. Now, my lord will kindly takes this next paragraph, my lord. In this case, there is no complaint regarding the service rendered before or after the death of CROI. The appellant has permitted the firm to reconstitute itself from time to time. It has renewed licenses of the reconstituted firm for a long period of time. So, my lord, all these were prior to the death of CROI, my lord. So far, so good, my lord.
It is not correct. They have allowed me to continue the file. That has been the observation. In case the appellant has permitted the firm to reconstitute.
Yes, it was allowed to you to continue the license.
Yes.
No, they,
And, still, and on the said basis, on this observation, I have been allowed to continue till now.
order says the farm.
The
Order says
reconstitution,
the
my lord.
farm.
My lord, the reconstitution of the firm was all prior to the death. First, by inclusion of the son, and second reconstitution by inclusion of the daughter-in-law, my lord. After death of all these reconstitutions were during the lifetime of CROI, my lord.
Yes.
After death of CROI, there was no reconstitution. Because prior to, my lord, death, the policy circular was followed, my lord, in totality. They have followed it, we have reconstituted it. Now, my lord, after the death of CROI, the firm has been reconstituted with the second and third respondent as partners. They have done it among themselves. The appellant should not be concerned as to the dispute between the second respondent and his half-sister. No, my lord, there is not a single averment anywhere that we are concerned with any dispute between the second and third respondent petitioners and the half-sister of the. There's nothing on record. We are not aware of the dispute. Nothing has been mentioned in the in the writ petition, my lord, that there is any dispute. So, my lord, we are dragging into dispute as now. All we are asking that you comply with the policy circular. We are not saying that you include her. We are saying get a no objection.
No, let me again find out the policy circular.
My lord.
That is the Reconstitution policy.
My lord will find that at page 130, 30 Reconstitution policy, my lord. It is at, it has been quoted in the judgment itself, my lord.
No, I have to see you from your policy circular.
My lord, policy, all right, my lord. Then my lord kindly takes page.
Page 83.
Yes. My lord,
83 the policy.
Page 83 of the writ petition.
Page 45 also, my lord.
Page 45.
My lord, page 83, I'm sorry, my lord.
Page 83.
Page 83. My lord, it is
yes.
At 1.5, in case of death of the partners, partner oblique, my lord, in brackets S, the partnership shall be reconstituted with the legal heirs of the deceased partner. My lord, kindly see, my lord. Shall be reconstituted with this. Shall is mandatory, my lord.
Yes.
Shall be reconstituted with the legal heirs of the deceased partner and surviving partners.
Yes.
However, if there is no legal heir or legal heirs has expressed their unwillingness, the dealership distribution shall be reconstituted with the surviving partner. So we have no objection, my lord. If they get a no objection from the legal heir of the deceased partner, we will reconstitute it, my lord. Now, my lord, will kindly visualize the situation, my lord. My lord, in the event, my lord,
Yes.
now, my lord, will
Whether any hearing conducted?
My lord, there was no opportunity of hearing granted by the division bench. The Honorable Court has said that you decided whether you will constitute based on the observations. If my lord kindly sees, no opportunity was given for hearing, my lord. Nor any hearing was insisted upon by the petitioners, my lord. Because it was to be decided.
Or the legal heirs has expressed unwillingness. The dealership distributors shall be reconstituted with the surviving partners.
My lord.
So you have not adopted that procedure,
my lord,
regarding accept of unwillingness.
My lord, the other
willingness or unwillingness.
Unwillingness, my lord, they have said that she is not coming forward. She is
So you
not
have to
giving no
ascertain.
objection.
You have to ascertain.
My lord, I will check because I think she was called for previously, my lord, before this division bench order. Earlier she was called perhaps, and she has both of them were called, and she
No,
has
after the division bench order.
after division bench they were not personally called. Neither of them, my lord.
No, if willingness or unwillingness has to be taken, then the person concerned has to be asked. This is the procedure actually. If you want to ascertain the unwillingness or
My
willingness
lord,
of
as per the procedure, my lord, the surviving partners are required to produce the no objection or willingness, whatever. Because if there is a reconstitution as per this particular policy, then they have to file my lord, a partnership form, including the including the legal heirs of
I
the
understand this is the general policy, but the
My lord.
division bench has directed upon some findings.
My lord.
So in that case, you have to ascertain the willingness or unwillingness.
My lord, let us read the division bench order
Yes,
once
yes.
again, my lord. My lord. 134, my lord.
Yes.
My lord, after these observations, my lord.
Okay.
In those circumstances, this court upholds the decision of the appellant to terminate the agreement.
Very well.
By virtue of the status quo order in this writ, the respondent firm continues to be a dealer of the appellant. It shall continue to do so on a temporary basis. The appellant is to take a decision, kindly mark this, my lord, as to whether it will renew the dealership with the reconstituted first respondent.
Yes.
So, my lord, before the division bench, at the point of delivery, the first respondent was already reconstituted by the second and third respondents, my lord. The son of the CRO and the daughter-in-law, they reconstituted among themselves, they furnished a partnership deed. So this was the situation before the division bench with the reconstituted first respondent on a permanent basis. On the basis of the above observation and after taking all relevant factors into consideration within 1 year from date. So, my lord, we were directed to take a decision based on these observations where the firm was already reconstituted with the petitioner number 2 and 3, my lord. My lord, even at this stage, my lord, the petitioner could have brought some kind of, my lord, compliance with regard to clause 1.5, either in the form of a no objection or maybe her consent that you continue with the reconstitution. Now, my lord, here I'll draw my lord's indulgence to a situation, my lord. My lord, this is this is within a family, my lord. My lord, kindly visualize a situation where two individual persons are partner, not from the same family. Now, the one person dies, the other person says, no, I will not take you, or your demands are not in conformity with my expectation. So I will continue. So this policy circular will be completely, my lord, made a redundant if it considered in a very liberally, my lord, as suggested by the writ petitioners before, my lord.
No, no. The issue is that policy circular is very, very clear.
Policy
If
circular
one of the partner expires, then the surviving partner shall reconstitute,
my lord,
with the legal heirs of the
deceased partner. My lord.
This is the policy.
My lord.
And if the legal heirs of the deceased partner are unwilling,
my
the surviving partner may continue. This is the
so
clause.
this
So how you ascertain the
my lord, this
unwillingness?
unwillingness will be either by way of an affidavit or some kind of correspondence. My lord, in this particular situation, my lord, the half sister, she came forward. She was a party in the first writ petition. She joined. She contested the matter. She did that I'm being deprived of my mother's share. She preferred an appeal from the single bench order, but did not pursue it. It was dismissed for default. So that was the situation before this honorable court, my lord, that she contested. She came forward and said that I am being deprived of the share of my mother. And the honorable division bench said that we should not get ourselves into the dispute between the first and second round under half sister. My lord.
That is correct. You have
we have no intention to get into the
you have
dispute.
no authority to get into the
My
personal
lord,
dispute.
absolutely. We are only confining ourselves to 1.5. That you resolve among yourselves. I am not concerned how you are resolving it. You either give me her willingness, unwillingness, and proceed.
Okay. I wanted to know whether such situation arise in any judgment law like that. Such situation.
My lord, I will ascertain. I've asked my client, my lord. I will find out whether similar type of situation is there or not. I will definitely because since we have a pan-India presence, definitely something might have happened somewhere. And what would be the the reaction of the court?
Now,
But
what would be the situation?
My lord,
what would be the situation if say there are two partners, one partner died, and the surviving partner says, no, I shall not continue the business. Then what would be happen to the legal heirs of the deceased partner?
my lord, in that case, my lord, the agreement comes to an end, my lord, because I have the judgment I have placed with Supreme Court judgment 2005. My lord, kindly takes that Sanjana, my lord, week. case I have placed before my lord, 2005 8 SCC. This is somewhat similar, my lord. Facts, my lord, the point was different before the Supreme Court, but this particular clause came for consideration. 2005 volume 8 SCC, my lord, I have handed up. भैया ये हाँ 242
2005 volume 8 SCC.
My lord, kindly text, my lord.
Sanjana, I am weak.
My lord, kindly text paragraph 2. The appellant herein, one Srimati Bimla Devi TO1, who were partners in Messrs. Tilak Automobiles, and respondent herein entered into a dealership agreement. Admittedly, the said agreement was terminated by the respondent herein by a notice dated 19th March 2004 in terms of clause 55 of the said agreement, which reads as thus. My lord, same clause here, my lord. Then, my lord, kindly text paragraph 3. According to the respondent, the said agreement came to an end on the death of the said Bimla Devi. However, the dealership was allowed to continue having regard to a representation made by the appellant herein that the firm had certain outstanding in the market, which were in danger of becoming unrecoverable if the supplies were suddenly stopped. The respondent agreed to continue supplies to the appellant on a purely ad hoc basis. Same situation here, my lord, on a different reason, my lord. 4. The respondent alleged violation of various conditions of the said agreement, namely low sales. Well, we are not concerned about. There are several allegations against was made by the oil company. Paragraph 5. A further notice was issued to the appellant by respondent on 7/11/2000, drawing her attention to the defaults made by her and warned that this was during ad hoc operation, my lord. Any future default would be viewed seriously and very stringent action will be taken. Thereafter, allegedly, a further default occurred, and thus, on the grounds stated in the notice, as also on the ground of default, the agreement was terminated in terms of notice dated 19th March 2004. Well, this termination was challenged, my lord. The appellant contended, then my lord, Mr. Lalit submitted on behalf of the appellants, a learned counsel appearing on behalf of the appellant at the outset drew our attention to the subsequent events which took place, namely that the referral of dispute of differences between the parties were referred to arbitrator. But with regard to that payment aspect, my lord, the dispute was referred to the arbitrator. Then my lord kindly skips, my lord. My lord, there are diverse, my lord, the counter arguments are there. Then paragraph, my lord, 13. Well, the argument was made with regard to arbitration clause 13, 14, 16 are, my lord, with regard to arbitration, my lord. 17 also. My lord, paragraph 18, my lord. It may be true that in a given case, when an action of the party dehoes the terms and conditions contained in the agreement as also beyond the scope and ambit of the domestic forum created, therefore, the writ petition may be held to be maintainable. But indisputably, therefore, such a case has to be made out. Then might kindly skip this with regard to arbitration only. Then paragraph 19, what was the outstanding mentioned, my lord? Paragraph 20, my lord. We are further of the opinion that in this matter, no case has been made out for grant of relief of restoration of the dealership. The contract is to terminated on the death of the appellant's partner. No case of novation of contract has been made out. It is also not the case of the parties that any other or further agreement with the parties came into being. The arrangement was an ad hoc one. The appellant did not derive any legal right to continue the business for an indefinite period. Moreover, she allegedly violated the terms of the contracts. So, my lord, here, my lord, the contract was upheld. Since the contract contained a clause that upon death it will come to an end, the Honorable Supreme Court was of view that there's no novation of contract. No new contract came into existence between the parties. And the Honorable Court did not find it a fit case to, my lord, set aside the order of termination.
Yes.
Now, my lord, my endeavor would also be to my lord, to place before my lord, what is the view of Supreme Court in these commercial contracts vis-a-vis the policy guidelines, my lord? The next, my lord, judgment I'll place 1994 4 SCC. My lord. My lord, we'll take paragraph 14, my lord, first. 14 is also that's the part. The contract between the parties is governed by statutory provision. Here, my lord, it was a statutory contract governed by a statute. But in our case, it was purely a commercial contract, not governed by any statute, my lord. The contract between the parties is governed by statutory provisions, the provisions of the Act and rules and the conditions of license and the counterpart agreement. They constitute the terms and conditions of the contract. They are binding upon the government and the licensee. Neither of them can depart from them. It is not open to any officer of the government either modify, amend or alter the said terms and conditions. Not even the Ministry of Excise. It is therefore not really necessary for our purpose to examine what precisely was the statement made by the Minister of Excise. Kindly skip this, my lord. No, last sentence. In any event, even the newspaper report does not say that he held out any assurance supply all additional quantities or as may be demanded by the licenses, additional quantities equal to previous year supply. All he said was that steps will be taken to supply requisite quantities of arrack soaps. Then my lord kindly skips, kindly takes paragraph 21, my lord. Well, kindly takes the last sentence at the bottom, my lord, page paragraph 21. It is not a case, my lord. From bottom, my lord, 7th line. It is not a case where any essential term of contract was kept back or kept undisclosed. The government had placed all their cards on the table. If we can use that expression, if the licensee offered their bids with their eyes open, in the above circumstances, they cannot blame anyone else for the loss, if any sustained by them, nor are they entitled to say that the license fee should be reduced proportionate to the actual supplies made. Question may arise, proportionate to what? Proportionate to their demand, proportionate to previous year supply. Kindly skip this. Paragraph 23, my lord. Maybe these are the cases where the licensee took a calculated risk. Maybe they are not wise in offering their bids, but in law, there is no basis upon which they can relieved of the obligation undertaken by them under the contract. It is well known that in such contracts, which may be called executory contracts, there is always an element of risk. Many an unexpected development may occur, which may either cause loss to the contractor or result in large profit. Take the very case of arrack contractors. In 1 year, there may be abundance of supplies accompanied by good crops, induced by favorable weather confidence. Then in another year, my lord, kindly skip this. But kindly takes paragraph 26, my lord. Learned counsel for the respondent and submitted that doctrine of fairness and reasonableness must be read into contracts to which state is a party. This was, my lord, the argument here also. It is submitted that the state cannot act unreasonably or unfairly, even while acting under a contract involving state power. Now let us see what is the purpose for which this argument is addressed and what is the implication. The purpose, as we can see, is that though the contract says that supply of additional quota is discretionary, it must be read as obligatory, at least to the extent of previous year supplies. By applying the said doctrine, it is submitted that if this is not done, the licensee would suffer monetarily. Same case here, my lord, the policy, they are saying that the policy guideline cannot be implemented because we have our partnership says otherwise. The other purpose to which it says that if the state is not able to so supply, it would be unreasonable on its part to demand the full amount due to its under the contract. In short, the duty to act fairly is sought to be imported into the contract to modify and alter its terms and to create an obligation upon the state which is not there in the contract. We must confess we are not aware of any such doctrine of fairness or reasonableness. nor could the learned counsel bring to our notice any decisions laying down such a proposition. Doctrine of fairness or the duty to act fairly and reasonably is a doctrine developed in the administrative law field to ensure the rule of law and to prevent failure of justice. Where the action is administrative in nature, just as principle of natural justice ensure fair decision, where the functions is quasi-judicial, the doctrine of fairness is evolved to ensure fair action where the function is administrative. But it can certainly not be invoked to amend, alter, or vary the express terms of the contract between the parties. This is so even if the contract is governed by statutory provisions. That is where it is a statutory contract, or rather more so, it is one thing to say that every contract must be construed reasonably having regard to its language. But this is not what the licensee say. They seek to create an obligation on the other party to the contract, just because it happened to be the state. They are not prepared to apply the very same rule in converse case, where the state has abundant supplies and wants the licensee to lift all the stocks. The licensees will undertake no obligation to lift all those stocks even if the state suffers loss. This one-sided obligation in modification of express term of the contract in the name of duty to act fairly is what we are unable to appreciate. The decisions cited by the learned counsel for the licensee do not support their proposition. In Dwarkadas Marfatia's case, my lord, note that famous case, my lord, it was held that where, my lord, the public prosecutors were, my lord, their appointment was cancelled. It was held that where a public authority is exempted from operation of a statute like Rent Control Act, it must be presumed that such exemptions from the state is coupled with the duty to act fairly and reasonably. The decision does not say that the terms and conditions of contract can be varied, added, or altered by imposing the said doctrine. It may be noted that though the said principle was affirmed, no relief was given to the appellant in that case. My lord, next page, my lord.
Yes.
Next, it was the case of termination from the post involving public element. It was a case of non-government servant holding public offices, on account of which it was held. Kindly skip this. We are therefore of the opinion that in case of contracts freely entered into with the state, like the present ones, there is no room for invoking the doctrine of fairness and reasonableness against one party to the contract, that is state, my lord, for the purpose of altering or adding to the terms and conditions of the contract, merely because it happens to be state. In such cases, the mutual rights and liabilities of the parties are governed by the terms of the contracts, which may be statutory in some cases, and the laws relating to contracts. It must be remembered that these contracts are entered into pursuant to public auction, floating of tenders, or by negotiation. There is no compulsion on anyone to enter into these contracts. It is voluntary on both sides. There can be no question of the state power being involved in such contracts. It bears repetition to say that the state does not guarantee profit to the licensee in such contracts. There is no warranty against incurring losses. It is a business for licensees. Whether they make profit or incur losses is no concern of the state. In law, it is entitled to its money under the contract. It is not if the licensee are going to pay more to the state, in any case make substantial profit. We reiterate that we have said here in above, it is in the context of contracts entered into between the state and its citizens pursuant to public auction, floating of tenders, or by negotiation. It is not necessary to say more than this for the purpose of these cases. So, my lord, the contract has been, my lord, it is the view of the Supreme Court that the terms of the contract should be, my lord, okay.
There should be no reasonableness,
my lord,
in deciding the contract,
my lord,
between the state authority and
my
the
lord.
private contract.
Because here, my lord, it's a commercial contract. Both the parties are participating in the, my lord, in the agreement with their eyes wide open. There's no compulsion on them to accept the terms. They can easily, my lord, refuse their consent and do not sign the agreement. But once, my lord, a contract is signed and the policies are framed, a contract says that the policy will be binding, policy guideline will be binding on the parties. I cannot deviate from the policy, neither they can claim that the policy is not binding upon them.
So you concluding?
No, my lord, I have some more decisions, my lord. 2-3 more decisions. I will close. I'll take half an hour, another half an hour any day, my lord.
Tomorrow will take 2 p.m.
Tomorrow,
half an hour only, since required, then I will complete on any other day.
Okay. Group 6 আছে কিন্তু not আছে ফার্স্টে মাত্র 6 আছে হ্যাঁ ঠিক আছে কটা আছে গ্রুপ 6 এর পরে রেখে দিই সব আর নেই তো এটার পরে এটা রেখে দিচ্ছি ও সিনিয়র কাউন্সিল 1 ঘন্টা
क्या बोलते
তারপর এটা রেখে দিচ্ছি হ্যাঁ মোশন আফটার গ্রুপ 6 এটা রাখবেন তারপরে মোশন রাখবেন ঠিক আছে tomorrow Thursday first up I have some group 6 matters only few matters are there after group 6 matter I will take up this matter it will be taken up within 11:30 or like that okay you conclude it?
Kindly fix it at 12, my lord, then it will.
I am fixing it tomorrow only.
Only tomorrow.
very well, my
This
lord.
will appear likewise. Okay. Not necessary to pass any order.
No, not necessary.
Not necessary.
Just adjourn, my lord.
Just adjourn. কালকে হয়ে রিস্ট করবে
My lord, had adjourned and parted because it should be parted. There is no mentioning of parted.
Okay. Please take down. Argument heard in part. Let the matter appear tomorrow after group 6 matters.
My lord.